Yes. I have a lawsuit kindly to mention one testamentary and intestate jurisdiction matter of the year 2017 for inclusion in the list.
My lord,
Inclusion.
yes, my lord. It's a testamentary suit, my lord. And there is one more application, my lord, connected
All right, it
to
will come in the list.
another, my lord, testamentary suit. I'm grateful.
Same.
No, my lord, this matter, if Lordship remembers, witness action was going on, my lord. Mr. Ghosh was on my other side. His witness was coming from Delhi, my lord. My lord, the matter was initially fixed on, my lord, 10th of December. And this matter was initially fixed on 10th of December, my lord, for my lord, cross-examination to be done. Now, 10th of December, my lord, some of the matter did not appear in the list. Now, on that day, my lord, my learned friend had mentioned, I mean, your lordship was pleased to keep it on 6th of January. My lord, somehow, my lord, that day also it has not appeared. My lord, may it appear any day, my lord.
My lord, could it appear any day in the first week of February, my lord, except between the 13th to the 17th?
No, not Friday. Next week. It will come in the next week. Friday, I will not.
His witness is supposed to
Lord,
come from
my-
outside. I have no problem.
My lord, my witness is coming from Delhi, my lord. He was being cross-examined. Could it be any day in the first week of February, my lord? Except
First week of February.
Yes, my lord.
I don't stand in the way in that event, my lord.
Only 3 days are available.
My lord,
7 February.
I'm great.
My lord, will it be lordship's pleasure, my lord, to record a small order, my lord, in that event,
This is not in the list.
as my lord, as mentioned, my lord.
Let us do one thing. Come in the list tomorrow. Let it come in the list tomorrow.
Let it be on Friday, my lord, in that event.
No, Friday I will not be sitting.
Monday, my lord, in that event. Tomorrow, my lord, I'm not
Monday,
there.
very dicey.
Let it be tomorrow, my lord. Let it be tomorrow, my lord. Let it, let it.
7th of February,
Let
but
it.
there's no difficulty.
Let it,
I
let it.
don't-
Okay, note kar now 7 February.
Let it, my lord, on 7th of February.
Eight, my lord.
Lord, your matter.
Lordship, upon mentioning, upon notice to the other side, Lordship, mentioning he's there.
Inclusion.
Lordship. Any day, Lordship, already the hearing is going on. Mr. Shuman Datta has already completed.
Which matter?
Lordship, the Arijit Das Mullik versus Government of West Bengal.
Application, I think.
It's a stay
Yeah.
application. Lordship.
Application for
First day of the
next week, not this week.
Lordship. Deeply.
Origin site commercial division, item number 1.
Lord, by consent of my lord, responding, my lord, I'm praying, my lord, not this week, my
Your
lord.
lord.
What is A6?
Is it my lord's pleasure?
A6 is their application for recalling of the ex parte decree, your lordship, which was adjourned on several occasions on their grounds. But now, your lordship, Mr. Shuddhashatta Banerjee is appearing for the petitioner. He had personally called my advocate on record since he is not well. Your
Not this
lordship
week.
kindly keeps it at the same position any day convenient.
Your Lordship, I appear for the plaintiff in this matter. I have obtained a decree they have come for recalling. Now, the several occasions your lordship has granted them time. Now, lordship will look at the last order. Last chance was given. Last chance. After several adjournments, last chance was given to Mr. Tiwari.
That's
to,
why not this week. I'm not passing any order.
Your lordship,
Next week I will not spare you.
My lord.
the lordship will kindly make it clear in the order that this is the last chance, because last time also your lordship has given
No,
last
then I
chance.
have to explain why after, in spite of passing this order of peremptory adjournment, I am still allowing it. Come on the next week.
Lord, which day, my lord? Next week,
They will check it.
Tuesday,
They will check it.
my lord.
Great.
Item number 2.
Yes, my lord. I appear for the plaintiff.
I'm appearing for the defendant.
My lord,
What
I
is
have-
GA-COM6?
Yes, my lord, I have been compelled to take out this application for amending the plaint. The reason because my lord, the name of the defendant has been changed. Now, my lord, I would only humbly beseech your lordship to take 2 documents. My lord, the first document.
Have you any
lordship-
objection?
No, your lordship. Lordship, we had intimated to them that
Yes. Now, my lord, kindly see. There has been
Where is the proposed amendment?
Yes. Page 31 onwards, my lord.
Private Limited.
Yes, it was Macmet India Limited before. Now, my lord.
It will be private limited.
Yes. Now, my lord, the only thing that I want to indicate is, my lord, despite the defendant being aware that their name was changed from limited to private limited in 2020, my lord, they intimated us on 6th of December 2024 after expiry of a period of 4 years.
Lordship,
But this is
if I
only
may,
to delay
Lordship,
the
if I may
hearing of
say-
the suit.
Lordship, no. Lordship, when as per the last order, we were directed to comply with the provisions of the Commercial Codes Act. Lordship, when we had sent the documents to the client, to MacMed, then we came to know that the name of the company has changed. Nature of the company has changed from a public
GA
limited.
Com 6 of 24 is filed. Praying for amendment of plaint. Namely, change of name of the defendant. From MacMed India Limited to MacMed India Private Limited. Proposed amendments are annexed. Amendments are formal in nature. Accordingly, prayer A to C of the master summons is allowed. Necessary steps shall be taken for carrying out the amendments. This suit will appear in the list on 25th February.
Grateful, Your Lordship.
Well, Lordship is
GA Com 6 of 24 stands disposed of.
My lord, pursuant to your Lordship's order of 10th of December 2024, Lordship has already directed the matter to appear on 17th of January. But because my
17th of January, okay.
grateful.
Grateful, Your Lordship.
Item number 3. Commercial Division, item number 3.
Here, my lord, application for my lord, amendment of my written statement.
Lordship, I'm appearing for the
GA Com 7.
yes, I'm appearing for the plaint.
Filing the notes of argument, my lord. Yes, made our submission.
May I file the notes?
Lordship's order was on 3rd of October. Yes. We had given my lord the proposed amendment correctly in the supplementary affidavit. So there was some mistake.
Where is supplementary affidavit?
There was some mistake in the written state proposed amendment shown in the statement which was annexed to the petition. This matter, my lord,
Now I have to pass an order then. This proposed amendment copy shall be ignored.
yes,
Otherwise, there will be a confusion.
yes. Because I think there is an earlier order, because your lordship gave me a leave to file a supplementary affidavit because your lordship.
Without allowing the amendment application,
Yes, your lordship is the 24th July 24 order. Lordship has recorded that. 24th July 24. He is given to counsel for defense file supplementary affidavit. The proposed amended written statement is not complete by itself. A hearing was concluded on 3rd October.
in terms of order dated 24 July 2024, this court allowed filing of a supplementary affidavit. Full stop. Mr. Sen, the learned senior counsel, filed supplementary affidavit containing proposed amendments, as corrected on 5th September 2024. Full stop. For the purpose of hearing and disposal of this application, the proposed written statement contained in the supplementary affidavit shall be counted and considered, ignoring the proposed amended written statement annexed to the application, namely GACOM 7 of 2024, shall be ignored. Otherwise, there will be utter confusion. Now, who is the defendant?
My learned friend is for the defendant, I am for the plaintiff. Lordship had heard my learned friend and my learned friend had placed certain case laws. Thereafter, I am led by Mr. Shoroshis Dasgupta. He had indicated the preliminary points. Your Lordship was pleased that the party should file the notes in the meantime. The notes have been filed. Perhaps the plaintiff has to be heard because we are opposing the application.
All right. Adjourn to
But again, after my notes, then I have to file a supplementary note in case I have to reply to them. I do not know if they may cite some new cases.
No, no new cases. We had already
Very-
indicated
very
the
well.
case laws on the last occasion.
7 February.
If necessary, kindly permit me to make a rejoinder for
Written notes of argument. Are you filing today?
Yes, that's fine.
Filed by Mr. Shen, be kept in record.
Both parties.
Lordship,
Both the parties
are
be kept
fine.
in record.
I'm great.
If kindly permit me to add something, if
I'm on the next day. If
Then
necessary, I will allow it.
Okay.
Item number 4,
I'm great.
7th February.
Commercial Division, item number 4.
I'm the defendant, but I'm the petition. It's my application. The GS6 for extension of time to file written statement. Well, the fact is, also may remember this before conversion of this, there was an ex parte order was there. But after conversion of the into commercial division, your lordship have filed an application for leave be granted to file the written statement, your lordship. The last occasion, I have made
Order sheet को तो देखिए.
submissions on this, your lordship. And also place a decision of the Honorable Supreme Court, your lordship, that even after declaration of, classification of undefended or ex parte, lordship, after conversion into commercial suit, my lord, written statement can be filed within 120 days, your lordship.
Where are these judgments?
My lord. My lord, I have placed judgment, your lordship, already recorded in our lordship, Honorable Supreme Court decision. Lordship, the citation is 2023. Starts from paragraph 8, your lordship. That paragraph 6, your lordship. Sorry, your lordship. Lordship, may I read out for you? Yes.
What are other judgment decisions we are citing?
My lord, this is the Honorable Supreme Court decision, your lordship, that another decisions of our High Court, your lordship. That is, your lordship. The copy. So this is also on this issue, your lordship. Lordship, paragraph 18 itself. Paragraph 22. The discussions over there, your lordship. May I read out, your lordship?
Yes.
My lord, may I proceed? My lord, I have filed an affidavit in this application, my lord. My lord will kindly take that affidavit once. Multiple
No, there is a point of law.
Yes.
I'll go on the point of law first.
Very well. My lord, point of law kindly takes the judgment which is, my lord, relied upon by my learned friend, the judgment of this Honorable Supreme Court in Raj Process Equipments and Systems Private Limited. My lord, the Supreme Court judgment that my learned friend relied upon. This is distinguishable on facts. Why kindly takes paragraph 6 and 7. My lord, paragraph 6 says trial court had passed an order on 3rd of July 2018 where two of the defendants, in spite service of summons, failed to appear, and two of the defendants, despite having an opportunity, failed to file the written statement. Hence, the suit was directed to proceed ex parte. And my lord, on paragraph 7, it says that after such and such was designated as a commercial court in terms of the Commercial Courts Act, the suit pending on the file of the Civil Judge Senior Division was transferred to the Commercial Court. After transfer, different numbers 1, 2, and 4, who are the appellants, herein moved 3 applications, condemnation of delay, recalling the order, and written statement. And for file, no written statement. My lord, so this 3 applications for recalling of the order and leave to file written statement was filed after the transfer. Here in this case, at least 3 applications were filed prior to transfer, and by an order, my lord, a reasoned order, my lord, this honorable court had struck out those applications, dismissed those applications, and closed the right to file written statement even before the transfer. Today, my lord, if my lord permits the written statement to be filed, it would be like my lord is sitting over appeal in respect of that order. That order, my lord, I have annexed in my affidavit. Second of all, my lord, if my lord sees the ratio which has been given in...
Where is this?
My lord, affidavit, yes.
Where is the affidavit?
Kindly takes my affidavit. It was affirmed on 17th of December 2024. Kindly comes to page number 9. I have annexed only the orders, my lord. Kindly
number 9.
Page number 9. This was the first time, my lord, when it was seen from the report that writ of summons was served, but none of the defendants entered appearance. It was marked as an undefended suit. Thereafter, my lord, they took out an application being GA number 3, my lord, for recall of that order and for leave to file written statement. That was, my lord, also dismissed.
That was dismissed.
My lord, dismissed for default. So they took out another application being GA4 for restoration of GA3. That order, my lord, begins at page number 11.
It was dismissed too.
It was dismissed, not only dismissed, kindly sees, it was dismissed with, my lord, reasoned. Kindly sees from page number 12. Page number 12, second last paragraph. Now the application being G3 is taken up for hearing. The defendant has prayed for recalling, modifying the order dated such and such, and prayed for extension of time to file written statement. Counsel for the defendant submitted that the writ of summons was lodged on such and such, but copy of the amended plaint was served a day before the summer vacation of the court. The specific contention of the defendant is that the defendant has engaged the counsel, but the learned advocate has not properly advised to appear in the suit and to file written statement. Counsel for the plaintiff has raised objection and submitted it. Well, kindly ignores the submission. Kindly comes to the reasoning portions. Next page.
So, all right. Your point is this court, the coordinate bench, passed a considered order. Now, if this is allowed, this is sitting as a court of appeal over the coordinate.
That is first point. Second point, my lord, kindly sees page number 13. The conduct of the defendants shown. Page number 13, second last paragraph. The defendant filed an application for extension of time to file written statement on 16th August 23. In the said application, defendant prayed for 4 weeks' time. In the meantime, said application was also dismissed for default. Defendant filed another application for restoration. This court has inquired from the learned counsel for the defendant whether the written statement is ready or not. But the counsel for the defendant, in his usual fairness, submitted that the written statement is not ready and prayed for further time to file written statement. This court finds that the application for extension of time for filing written statement is filed in the month of August 23, but till date, and till date meaning, my lord, this order was passed on 13th of February 24. Till date, the defendant is not ready with the written statement, and thus this court finds that the defendant is not seriously intended to contest the suit. This court also finds that only defendant number 1 has filed an application for extension of time, other defendants have not. So, my lord, this was closed. Now, my lord, kindly takes the Supreme Court judgment once again, which was relied upon by my learned friend. Kindly sees paragraph 13 and 14. My lord, this was the 2 paragraphs that was relied upon by my learned friend. My lord, this was a case of post-transfer, but the application for filing of written statement was made post-transfers. No application was made prior to transfer. We do not agree.
Let me go through these judgments. There is a certain distinguishing factor possible.
Yes, my lord, the only thing that I wanted to argue today is, even if it is taken by your court that this honorable court has the discretion.
Second thing is whether when the things are not complete at the time of transfer.
Section 15, my lord.
That is the key.
Absolutely, my lord. So this was closed. This was closed. There is no scope of
At the
reopening
time of
it anymore.
transfer, there was no pending proceeding.
No pending proceeding. The written right to file written statement was closed even prior to transfer. Just because the matter was transferred does not give the defendant a fresh lease of life to make another attempt, the fourth attempt to file the written statement.
All right, I will go. Let me
My
go
lord,
through.
may I just reply? Give a short reply, Your Lordship.
I'm not
I have a-
passing any order
No.
today. Let me go through it.
Your Lordship will keep it in any way.
Tuesday?
Very well. My lord, only one thing.
No, not Tuesday.
My lord, kindly look
Let
at
me go through it. I will appreciate your points.
My lord, the order dated 25th November grants
me go
me
through it.
leave to apply before this honorable court. High Court order
12th February.
12th February.
I am grateful to my lord.
এটা আমাকে পাঠিয়ে দেবে চেম্বারে।
And since my lord is considering this matter, my lord will also consider the judgment of Salem Bar Association, which is referred in the Supreme Court judgment, which says that may be a discretion of the court. The application does not disclose one line of explanation as to why the written statement
My lord,
could
the
not be
time
filed.
limit
This
starts running
application,
from the day
it is not a
the conversion takes place. And
If
it's
the
on
proceedings are not pending,
No, my lord, the
proceedings
have
are
been declared
pending-
ex parte. Supreme Court saying that
Let me go
even
through
if
it.
the proceeding has been declared, and my lord, there is another judgment of this honorable court as well on the same pat point, that even if the proceedings have been declared to be ex parte and the defendant's right to file the written statement has been closed, then also, my lord, the time will start running afresh from the time the conversion takes place for a period of 120 days according to 15(4) of the Commercial Courts Act. And Order 8, Rule 1 will not apply of the CPC over here.
Should we come with a written note, my lord?
No, let me go through it.
Yes.
I think this is section 15. Subsection 3, 15 subsection 3, man.
Let me go through it.
We'll come back on 12th, man. I'm grateful to him.
Deeply obliged, Your Lordship.
Item number 5.
Item number 5.
5, I was appearing on the virtual mode on behalf of the defendant, who is the applicant in IAGA 2.
I'm for the plaintiff, my lord. The lordship's last order directed us to comply with the Commercial Courts Act rules because that we prepared the statement of truth and the affidavit of competency, my lord. I'm only requesting for a little more time, my lord. The list of documents is yet to be finalized. my
Statement
lord.
of truth, affidavit.
Statement of truth and affidavit of competency both have been filed in the department. The only thing, my lord, the list of documents we are yet to finalize, my lord.
What about this application?
Man, the application, I'm the applicant in IAGA 2. They have, day before yesterday, given us a copy of the opposition. So kindly extend my time to file the affidavit in reply.
Yesterday,
Your yesterday. I'm so sorry. And kindly give some date in February because of an injury I've suffered. This month, I will not be able to appear physically.
Adjourned to 24th February.
Grateful.
Affidavit
And
reply to GA number 2 of 23 shall be filed in the meantime. What do you want to file? Affidavit of documents.
My lord, the plaintiff, the documents, affidavit of documents, my lord.
Affidavit of
Special
documents shall be filed on or before the returnable date.
Grateful. my lord.
extremely grateful.
Opposition to file.
Grateful, my lord.
Item number 6.
Please, my lord. But I am for the plaintiff in the matter, my lord. My lord, the defendant in the matter have taken out an application GA for transferring of the suit from commercial to regular division. my lord. Although the suit was transferred by your lordship's order on 1st March, after 4 years they take out an application, my lord. But nevertheless, my lord, I am ready with the affidavit in opposition. But I have already served them, but we have not received any reply of it.
Lordship, I am for the defendant number 1. Kindly give us 2 weeks time to file affidavit.
opposition. We are unable to communicate with defendant number 1. He is outside of country.
An accommodation is sought for to file affidavit in opposition. Let the suit appear in the list on 21st February. Affidavit in opposition shall be filed on or before the date.
Affidavit in opposition I am submitting.
Affidavit in reply.
Reply.
Sorry, ওটা reply করে দাও.
This may be taken on record.
Affidavit in opposition filed by the defendant.
No, I am the plaintiff.
Filed by the plaintiff be kept on record.
Framing of issues, item number 7.
Rather for the plaintiffs in this matter, my lord. Today, my lord, the matter has been kept for the witness to identify a few documents, my lord.
No, my lord, we have on the last occasion, my lord, we have taken out a suggested issues, my lord, before lords.
Have been framed, my lord, on the earlier occasion. My lord.
Issues are framed.
Have been framed, my lord. It is wrongly appearing under the heading of framing of issues, my lord.
Yes.
Lord, today the matter has been kept for the witness to identify.
It should be for witness action.
Correct, my lord. Lord, the witness is suffering from a bout of illness, my lord. I'm praying
The
for
suit will appear in the list under heading witness action since the issues have already been framed. Let the suit appear in the list on 14th February. No, not 14th. 18th February.
Grateful, my lord.
Witness
এই
action.
18 নাম্বার কোনটা ডাকছেন? 7 হবে তো, ওখানে কি দেখাচ্ছে?
It was 7, man.
Yes. You're showing 6.
Witness action, item number 8.
Lordship, I appear for the plaintiff. My witness was on the dock, in the middle of which my learned senior friend appearing for the defendant has filed an application under Order 7, Rule 11. Lordship, affidavits are complete. My learned senior friend will place the application.
Lord, kindly Miller takes up the plaint, Lord, on the last day or day before yesterday when it appeared, Lord.
Did not you read the plaint all throughout these years?
Lord,
Did not you read the plaint? Certainly you discovered the
I
plaint
read.
is liable to be rejected.
I read, Millard. I read, but Millard, with greatest of respect, Millard, there is no limitation with regard to filing of
It's
an
not a question
application
of
under Order
limitation.
7, Rule 11. If it is found, Millard, it's barred, Millard, the court will take a serious note of it. And the Lordship's view is also the same. Millard, kindly, Millard, comes to page 8 once, Millard. The plaint. Only 3 paragraphs, Millard, I would place before your Lordship. First, Millard, kindly comes to paragraph 8, page 12. That is their claim, narrated in this paragraph. Lordship has got it, Millard. Under the circumstances, the plaintiff is entitled to the amount from the defendant as per the particulars mentioned herein below. Particulars. Number 1, payment for dolomite supplied to different blocks of district of Nodia. That is 1.
Just a minute, let me go through it.
Lordship.
Tenancy. ये
Kindly consider paragraphs 3, 4, and 5 and this paragraph. On the last day, Millard, when I was addressing Lordship, has taken note of 2 dates, Millard.
Yes.
Millard, kindly, Millard, comes to paragraph 8, Millard, if Lordship is...
Paragraph?
8. That's their claim, Millard. Under the circumstances, the plaintiff is entitled to the amount from the defendant as per the particulars mentioned herein below. Then they give given the particulars. First,
Payment for the dolomite supplied to different blocks of district of Noida. They have quantified 31,49,380. That is their first claim for supply of goods and non-payment. Now, claim 2, refund of forfeited earnest money which was done illegally, 1,50,000. Claim 2. Claim 3 also, refund of the amount deducted from the bills for dolomite supply delivered in Paschim Midnapur district so-and-so as per the instructions of the managing director of the sheet corporation. Last is the interest component. I am not on that. So, my lord, the claim is twofold. First, for non-supply, and second is the forfeiture of the earnest money and deduction. Two heads, their claim. Now, my lord, kindly, my lord, comes to paragraph 3 first.
Deduction.
Deduction.
Forfeiture was made on 14/12/2010.
Absolutely. That is the second part of the claim. Forfeiture was made.
And suit was filed on 2/5/13.
Yes, but kindly, my lord, consider the another date and the first claim. First claim. That's why I'm saying claim, my lord, is twofold. First is for payment of the material supplied.
No, even though if I agree with you, even this part of the claim be rejected or be barred by law of limitation, still one part prima facie.
Prima facie.
Supposed to be surviving.
Yes, I would show, my lord, that is also not. That is also.
That's a question of fact.
Just let me, my lord, address. Now, my lord, with regard to, my lord, the first part. Paragraph 3.
Submitted bill on 14/3
March 2010. So supply has to be made prior to that.
Yes.
Can't be before. Now, my lord, kindly see when the plaint was filed.
2/5/13.
20th April 2013. Admittedly,
2/5.
It was affirmed. I can
Date of filing 2/5/13.
2/5/13. Very well, my lord. I would take the date of affirmation also, 20th April, before that. So after 3 years. After 3 years. And there is no whisper in the plaint about the cause of action, when the cause of action is accrued. Generally, in a plaint, lordship would find always, my lord, we plead, my lord, when the cause of action is accrued. We say as a general averment that the suit is barred by limitation, then the cause of action, which gives me right to sue. Surprisingly, in this plaint, there is no averment with regard to the accrual of the cause of action. Now, with regard to first claim, kindly see nothing. No averment when the cause of action has accrued.
Yes.
Now, my lord, kindly takes the Limitation Act. I am addressing on the first. According to me, my lord, subject to correction by the court, Article 14 probably applies. Here, my lord, the entire contract was based on a notice inviting
Delivery
tender.
of goods, yes.
Yes. So 3 years. When, my lord, no fixed period of credit is agreed upon. Where?
So according to you, goods must have been supplied prior to 2009.
14th March 2010, when they submitted the bill. Bill could not have submitted prior to supplying. After supplying only the bill could have submitted. And they are submitted on 14th March. So supply made before that. Suit filed on 2nd of May, admittedly beyond 3 years. And the relevant article is Article 14, when there is no fixed period of credit is agreed upon or mentioned, 3 years. Straightway their claim is barred. Now, my lord, the relevant document which they have referred to in the plaint, I must show your lordship. Notice inviting tender. It's part of the document. And my lord, lordship can take it. I will provide my lord a copy.
Only one document is there.
Notice inviting tender possibly.
No.
One
Along with
letter,
the
my lord,
plaint,
then I need not. But this is the contract.
there is only a single document.
That's a letter, my lord. That's a letter.
Nothing else. Nothing can be looked into.
Very well. Absolutely. Then lordship would not look into this. But I can tell you, lordship, if lordship sees, because they have taken this point in their opposition, there is no fixed period of time or credit mentioned in the notice inviting tender. They have taken this point. I thought I would deal it. But lordship need not, because this is not a part of the plaint. And only the plaint and the annexures are to be looked into for the purpose of deciding the fate of Order 7, Rule 11, and nothing more.
All right. According to you, it's time barred.
Now, my lord, kindly comes to the second claim. Lordship has seen the earnest money, paragraph 8. First claim is straightway barred. Paragraph 8, the other refund of forfeited earnest money and wrongful deduction. That's the second claim. 21 lakhs and 1,50,000. Running page 12, paragraph 8.
Paragraph?
Paragraph 8, running page 12. They have narrated. So first claim I have dealt with. Second claim, refund of the forfeited earnest money which was done illegally, and refund of the amount deducted from the bills. So wrongful deduction obviously has to be 1,50,000 and 21,75,000. These two. Now, on what basis we have forfeited? That's a very important thing. Kindly comes to paragraph 4. Lordship was referring to another document, my lord. Letter. Now, my lord, may I place, my lord, paragraph 4. This is relating to the second claim. First claim is relating to the supply and the bill. That's a different thing altogether, which I have answered. Now it's a second claim, second component. After lapse of, may I, my lord, paragraph 4. Paragraph 4. After lapse of long 9 months, the defendant, by its letter dated 14th December 2010, allegedly.
So impliedly, supplies were made even prior to this.
Absolutely, absolutely, my lord. Their own admission says that the bill submitted on 14th March. They can't just wriggle out from this admission. And there is no pleading to the cause of action. It's an important thing. Now, my lord, the paragraph 4. After lapse of long 9 months, the defendant, by letter dated 14 December 2010, allegedly informed the plaintiff that the dolomite supplied by the plaintiff was of substandard or inferior quality as appear from the analysis report of dolomite samples. Next paragraph. The plaintiff was completely surprised to note that the content of the said letter dated 14 December 2010 and immediately protested the said report. Kindly take note of it. The report. They referred to a report on the ground that no sample supplied dolomite was ever collected in presence of the plaintiff or his authorized representative. It was further contended that to collect fresh sample of supplied dolomite in presence of the plaintiff and to send the same to specified laboratory for test, the alleged analysis report of dolomite supplies samples which were collected unilaterally without the knowledge of the plaintiff, and as such, the plaintiff did not accept the said analysis report. It is also stated in connection by the said letter dated 14 December 2010, the defendant intimated that the earnest money of rupees 150, lordship has seen, now this amount tallies with this, have been forfeited towards alleged loss and damage sustained by the defendant corporation. However, the plaintiff categorically denies and disputes the legality of the said forfeiture, as the said forfeiture was purely unilateral, arbitrary, whimsical, and without any legal basis. It is also stated in connection that as per the instruction of the
Yes, yes. What is your submission?
Second is also, second and third, these two claims are on the basis of a letter which, my lord, is a part of the report. So they say they have not received the report. Report is whimsical, arbitrarily done, everything, blah, blah, blah. Now, my lord, they have not challenged that report. Their claim of forfeiture and wrongful deduction would only survive when they, my lord, challenge the report. Because in the report, we have said the quality was substandard, and they have averred in paragraph 5.
That is not a issue to be decided for limitation issue. Whether the report should be challenged or not, that's a question of merit.
I'm not on that. I'm not on that. Now, my lord, if the letter reflects to a report, admitted position, they have not challenged admitted position. Their claim is based on the report, because report says that's a substandard quality. Now, when do you, my lord, when you get the right to lodge your claim when there is a report according to you is bad, whimsical, arbitrarily done. That, my lord, has been narrated in Article 100 of the Limitation Act. Kindly have a look at this article, my lord.
That is an article?
Article 100. The second component, second claim, is based on a report which they say is arbitrary. Article 100, kindly have a look at this. And the letter has also not been challenged. But they're asking for money because they say it's a wrongful deduction.
100 is other than a suit or any order of the government?
Yes, that's an order. Report is an order.
Other than an order?
Kindly, to alter or set aside any decision or order of a civil court in any proceeding other than in suit, or any act or order of an officer of government in his official capacity. It's a government company, no doubt. And the report prepared, filed, submitted by an officer of a government. This or is to be constituted as a conjunctive, my lord, here, not disjunctive. Kindly may I read. To alter or set aside any decision or order of a civil court in any proceeding other than a suit, then comes or any act or order of an officer of government in his official capacity. The person who prepared and filed a report is an officer of the government. It's a government company. Now, what is the time limit? 1 year. The date of the final decision or order by the court, or the date of the act or the order of the officer, as the case may be. Either this or that. Here, my lord, it's a report of an officer who has prepared the report in his official capacity, working as an officer of the government company. That's 1 year. So how do you substantiate your claim or demonstrate that you have a claim of 21 lakhs plus 1,50,000 when you don't even challenge the report or the letter itself?
All right.
Lord,
Got your points.
Just these 2 points. And my lord, few decisions I will be citing. My lord, I would not trouble your lordship on this proposition that Order 7, Rule 11 cannot be filed. It can be filed. Even when the witness is in the box, it can be done at any point of time.
It can be kept in record.
Lord,
This one. It
this
now?
one. Well, then we'll kindly have a look at clause 17. If lordship wants to see, just clause 17. Clause 17 of NIT. So this is the
Clause 17 of this notice inviting tender.
Yes, that relates to the payment clause. Kindly see.
I will not look into it because this is
Very
not
well.
part of the plan.
Very well. If they place it, then lordship, Lord, absolutely, I leave it to the lordship's direction.
Is it near now?
Now, my lord, kindly have a look at the judgments, my lord, which I intend to rely upon in this regard. Three decisions, one of your lord, this court, my lord. First one, my lord. 2007, Volume 5, Supreme Court Cases 614. I got your check. 2005, Volume 5, Supreme Court Cases 614.
Which para you are referring to?
Well, paragraph 25. Generally, court below doesn't because it's a mixed question. But when on the face of it, a part or the full claim,
paragraph
25, appears to be barred by laws of limitation, court would not encourage the litigation. It deals with Order 7, Rule 11 application. Paragraph 25, my lord, it has been discussed, my lord, elaborately. The language of Order 7, Rule 11 is quite clear and unambiguous. The plaint can be rejected on the ground of limitation only when the suit appears from the statement in the plaint to be barred by law. Mr. So-and-so did not dispute the law within the meaning of Clause D of Order 7, Rule 11 must include the laws of limitation as well. It is well settled that where a plaint discloses the cause of action is essentially a question of fact. Here there is no cause of action. Nothing has been pleaded.
That means your prima facie reading of the plaint
Absolutely,
shows that the suit is barred, then it will be rejected. It can be rejected.
Absolutely. Should be. It should be.
Should be, yes.
And my lord, the other two decisions, my lord, the other decision which I rely upon, my lord, that is, my lord, 2005, Volume 5, Supreme Court Cases, page 548. Paragraphs 3, lordship can take note of 4 paragraphs, paragraphs 3, 16, 17, and 18.
Paragraph 16.
Paragraph 3, my lord, 16, 17, and 18. 3, my lord, discusses with the facts. I need not trouble your lordship. 16, 17, kindly, my lord, sees, my lord.
All right.
On this point, my lord, here also suit was dismissed. Because on the face of it, it appears after seeing the cause of action that it's barred by the laws of limitation. It's prima facie barred by limitation. And the last one of this court, my lord. Lordship delivered judgment on 19th of July 2024 on an identical issue. The court, my lord, dismissed, my lord, the suit, allowing Order 7, Rule 11 application on the point of limitation.
Yes, I can remember.
Yes. So these three, my lord, I rely upon.
All right.
After my learned friend addresses the court, my lord, if new points he urges, my lord, then I would deal, my lord, and also the notice inviting tender clause.
Would you argue today?
Lordship, I am being led by Mr. Bose, learned senior counsel. May we come back another day? A short date with
Part in part adjourned to 24 January.
But, let the suit also appear because there was some confusion on Tuesday. Suit appeared, but the application did not. Let suit and application both appear on that day. my lord.
Let the application appear because it's a question of rejection, whether the plaint will remain or not.
Suit can't be possibly heard. If otherwise, my lord, there will be another date.
Not appear under the heading witness action, sir. Let it appear under.
Let it appear under
Suit along with the
heading
application shall appear in the list
adjourn motion.
for
Adjourn
hearing
motion.
of application on key date bolam 24 January
Under the heading adjourn motion because lordship is hearing.
for hearing.
Very well.
I am obliged, my lord.
Great.
Just that minute. I'm just photo to you.
I'm grateful.
Item number 9, Commercial Division, item number 9.
Item number 9, Lordship, Saurabh Mukherjee is appearing for the defendant number 2. Defendant number 2,
What about
Lordship.
item number 8? Oh.
Lordship, 9, Lordship, Saurabh Mukherjee is appearing for the defendant number 2, Lordship. But due to some medical emergency, Lordship, he has not come to court, Lordship.
Adjourned to 10 February.
10
Item number 10,
Much obliged.
For the plaintiff in this matter, my witness is here. He's in the middle of cross-examination by the defense.
Surajit Maiti.
ওদের একটু লেটার অফ অথরাইজেশনটা দেবে বোর্ড রেজলিউশন একটা কপি দিয়ে দেবে। জানুয়ারি রেকর্ডটা চেম্বারে
Mr. Dotto, you are here in this matter.
এশন করবো না বোর্ড
He is PW1.
is PW1.
You are for defendant.
I'm for the defense.
Thank you.
Mr. Baid, are you aware of any person, namely Shayantan Bhattacharya?
হ্যাঁ আমি জানি সায়ন্তন ভট্টাচার্য।
Yes, I know Mr.
সায়ন্তন ভট্টাচার্য।
How he is connected with the plaintiff company?
উনি লিগ্যাল এক্সিকিউটিভ ছিলেন আমারই নিচে।
He was the legal
executive
of the
company.
plaintiff company.
Was he aware of the facts and circumstances of the instant case?
হ্যাঁ হ্যাঁ
Yes.
yeah yes
I suggested to you that you have not verified and affirmed the copy of the plaint filed in this particular matter before this honorable court.
প্লেন যেটা দেওয়া আছে সেটা আমি পড়েছি জানি।
I do not.
না না প্রশ্নটা কি বললাম বুঝিয়ে দিন
That you have not verified an account copy of the plaint filed in this case before this honorable court.
আমার প্রশ্নটা হচ্ছে মানে উনি ভেরিফাই করেছেন কি করেননি ওইটা
কোনটা যেটা আমি সামনে প্লেনটা তো আমি ভেরিফাই করেছি আমি পড়েছি
Are you still associated with the plaintiff company?
Yes.
So what is your age?
Now 47. Surajit Maite. Myself Surajit Maite.
তুমি প্রদীপ ভাইদের দিয়েছো কেন
ক্যান্সেল করা হয়েছিল
Witness, when was the last agreement executed by and between the plaintiff and the defendant?
Last agreement হয়েছিল August 2011. Agreement was executed on from 1st August to 30th June 2012. 1st August 2011 to 30th June 2012. Last agreement যেটা executed হয়েছিল.
Are you the signatory of the last agreement?
No. আমি last agreement এর signatory আমি ছিলাম না. No, I was not. Last agreement.
Who signed the last agreement?
Last agreement signed by Mr. Amit Latsaria. Latsaria. कैसे आ रही है?
Can you tell when was the first agreement executed by and between the plaintiff and the defendant?
1st February 2006, I think. It is 31st January executed between that and agreement.
1st February 2006.
For 11 months.
For 11 months.
December 2006. February, March, April, May, June, July, August, October, November. December 2006.
1st February 2006 to December
2006.
2006 for 11 months.
2006, right?
What was the purpose of giving any security deposit to the defendant?
Security deposit for sir I have to check মানে আমি চেক করব তারপর দেখে আমি বলতে পারবো এটা ব্যাপারটা কেন প্রকাশটা হয়েছে then I can say.
Is it your case that the plaintiff has deposited any security deposit to the defendant?
We have deposited a security money to the company MM Industries.
We have deposited
To the company. To the defendant company.
the defendant.
Defendant.
Are you aware meaning of the word security deposit?
Sir, I have to check. Deposited money. So I have to check and I have to then মানে আমি দেখে তারপর and then I can answer.
Where will you check? In the legal dictionary? I check for.
না আমি একবার চেক করবো কোথা থেকে লিগ্যাল ডিকশনারি হতে পারে বাই এনি মিনস I can check from
I may check if in the legal dictionary
or anything any other things.
Was the security deposit provided by the defendant, by the plaintiff to the defendant, interest free?
No. Interest bearing.
It was interest free.
It was interest bearing.
when the plaintiff has handed over the possession of premises number 138 Grand Foreshore Road, Howrah, to the defendant?
After incident of fire, after incident of fire আমরা হ্যান্ড ওভার করে দিয়েছিলাম ওনাদেরকে।
After the incident of the fire, we had handed over the
Premises to the defendant.
Can you mention the exact date when the plaintiff had handed over the premises to the defendant?
I have to check. To check then which date I have, মানে আমরা কোন ডেটে হ্যান্ড ওভার করেছি আমরা
I have to check the exact
date and
in
then I
which
will
we had handed over the property to them.
exact date.
On which we had handed over the property to the defendant.
Mr. Maiti, I suggest to you that the interest deposit given by the plaintiff to the defendant was interest free as per the agreement.
The interest deposit means
interest free.
No.
Security deposit was interest free, according to him.
No. That was not interest free. And that is security deposit was refundable security deposit. Refundable security deposit.
The security deposit was not interest free, it was refundable security deposit.
Refundable security deposit.
Refundable security deposit.
So, Maiti, have you perused the last agreement dated 30th of July 2011?
31st July 2011. 31st July to the last agreement যেটা ছিল, হ্যাঁ, I have seen that agreement.
Am I correct that as per the agreement, the defendant had to take appropriate steps for prevention of the firefighting?
To kindly repeat করবেন এটাকে আরেকবার যেটা আপনি বললেন।
বলে দিন।
As per agreement.
As per the agreement.
Sir, agreement, I have to check that agreement once again and then I will reply.
Check, go through the
Agreement and then I
can
will answer this question.
Show the agreement for refreshing memory. If every answer is I have to check, then why he has come to this court?
Agreement copy.
July.
Exhibit number.
Is it exhibit?
Yes, Your Lordship, it's an exhibit. একসঙ্গে সবগুলো করা আছে। কালেক্টিভ পুরোটা কালেক্টিভলি তাই তো
31st July last agreement.
এটা দিন। প্রশ্ন করে দিচ্ছি।
ওখানে একটা কথা লিখে দাও, witness is shown the agreement, exhibit B.
কোন ক্লজ 9টা দেখিয়ে দিন। ক্লজ 9টা দেখিয়ে দিন, শরীর নষ্ট হবে না।
Yes, we have taken steps. আমরা স্টেপ নিয়েছিলাম ওখানে যে ফায়ার বা এই ধরনের যদি কোনো ফ্ল্যাটস বা লিকেজের কোনো প্রবলেম থাকে তা সেকেন্ড অ্যাপ্রোপ্রিয়েট স্টেপস ফর প্রিভেনশন অফ অর ফাইটিং ফায়ার।
Defendant has taken
Second steps.
Yes, the defendant. আপনি যেটা বলছেন।
হ্যাঁ, আমরা এই ফায়ার ফাইটিং এর জন্য আমরা স্টেপস নিয়েছিলাম, প্রিভেনশনের জন্য আমরা স্টেপস নিয়েছিলাম। আমাদের
For the prevention
appropriate যে স্টেপস আছে সেই স্টেপস আমরা ফলো করি
prevention of fire for firefighting.
appropriate
Prevention of firefighting or prevention of fire?
Prevention of fire.
or fighting fire
Or fighting fire.
fighting fire
This wording, your lordship, is firefighting. So, fighting fire.
Taking steps for firefighting or taking steps for prevention of fire?
prevents the second party side
Firefighting.
take appropriate steps for prevention of or fighting fire
The wordings are not, your lordship. Had the plaintiff installed water sprinklers in the godown?
appropriate steps have been taken appropriate steps ছিল স্প্রিংকলার ওই যে আইটেমগুলো
Give the answer whether sprinklers were installed or not.
নো স্প্রিংকলার বা ছিল কিনা আমি এখন ঠিক মতো বলতে
I
পারছি
cannot remember.
I cannot remember
Are you aware that the plaintiff had installed any firefighting equipments inside the godown?
yes
Have you disclosed any documents before this honorable court to show that the plaintiff has installed firefighting equipments before inside the godown? আপনি প্রডিউস করেছেন কিনা আছে না
প্রডিউস করেছেন যেখানে
না
firefighting
প্রথমত আমরা করা হয়নি নেই এখানে দেওয়া হয়।
no such documents are produced here. No such documents.
Mr. Maiti, am I correct that as per the agreement, the defendant was not responsible for any incident to be occurred due to fire? Clause 9 টাই দেখবেন হ্যাঁ দেখুন দেখা
কি কোশ্চেনটা ক্লিয়ার হবে না
Am I correct? The defendant was not responsible for
not responsible for any manner also including in the case of any theft fire leakage yes agreement dated 30th day of July
Am I correct that the plaintiff am I correct that as per the agreement, the plaintiff had to use and occupy the space at its own risk and responsibility?
and security of its goods lying in the said space আরেকবার বলুন কোশ্চেনটা
আপনি ক্লজ 9 টা দেখুন না তো বুঝবেন না
yes
আবার দিন shown clause 3 clause 3 টা দেখুন am I correct that the interest the security deposit paid by the plaintiff to the defendant was interest free clause 3 টা দেখুন shown clause 3 করে দেন
it is interest free security deposit
yes
yes
it's interest free
security deposit
am I correct that the plaintiff was required to hand over the godown to the defendant as per the position when the plaintiff was inducted? ক্লজ 3টাই দেখুন আপনি।
Witness should be prepared. He has not gone through this document, wasting the time of this court. Next time you come, before deposing here, go through all these documents. I have to check. If you say this one, I will take action against you. PW1 is partly cross-examined. Further cross-examination is deferred to 10th February. Every answer is I have to check. Why have you not checked it? Get down. ওই অবধি থাকবে। তাহলে ওটা কেটে দাও।
লাস্ট প্রশ্নটা কেটে দেবেন। গ্রেটফুল।
Regular list. Item number 1.
Is appearing at our instance under the plaintiff in the suit. The suit along between the same
GA2.
Item number 1.
GA2. What is GA2?
Well, this is the suit filed by my learned senior friend's client. I'm the defendant.
Tell your lordship. It was a suit filed by me, which was in the other court, other suit court. There is a similar suit between the parties. I say similar because a lot of the prayers are common, which is pending before your lordship. Now, on the last few occasions, I've been making a prayer that the two suits should be heard together. It was the observation of the court that unless the other suit is released, it cannot be done. Such was also the observation of
This is suit filed by you. That means you are tenant or landlord.
Tenant.
I'm the tenant.
That's their alleged
For a
contention.
declaration that I am a tenant and entitled to
The other suit must be for
Eviction.
eviction.
That's my suit for
Now,
eviction.
my lord, my suit was lying before another court. Pursuant to observations from your lordship and insistence made by them that a formal application should be made, we had moved an application for release of the other matter. The learned judge, after hearing the matter at length, was pleased to release the suit. We therefore thereafter applied for assignment. It has now been assigned before your lordship. Now, the other suit is due to appear on the 10th. I was praying, may this suit also...
10th this month?
Yes. May this suit also appear on the 10th. Thereafter, my lord, we will have submissions to make. It's not as if the suit will be taken up on that day itself.
10th is a little bit dicey, sir.
Then kindly...
I'm fixing it on 10th itself.
Yes.
Another date will be fixed.
Very
My lord, only one submission. I don't stand in the way. My lord, will fix it whichever. It's his suit. My lord, my suit, there's a pending chapter 13 or order 13A application.
All right. Both
That's a
will come
commercial.
together.
My lord.
Let both the suits be clubbed together first.
My lord, it cannot be clubbed together. There's a pending, my lord, a subsisting order passed by the Honorable Justice Shonji Banerjee in this very suit, my lord. They had filed a prior application seeking clubbing of the suits to have them heard
All
analogously.
right.
That was
That is
rejected.
kept in the single day.
Yes, that can be done. My lord. That I cannot oppose.
Adjourn to 10th January 2025.
I'm grateful.
Obliged.
You are appearing in which matter?
This matter, item number 1, madam. I'm assisting Mr. Bose.
Okay.
Item number 2.
Appearing at my instance, the defendant number 1 in the suit. But since 2013, the suit has been pending.
Who is the plaintiff?
Plaintiff is not here.
What is the status of the suit?
Nothing has happened. I find a judge's brief of documents. That's
Written
been
statement is filed?
Written statement we filed.
Disclosure inspection?
That has also not happened. We've not filed a judge's brief of documents. Issues have not been framed. More importantly, I think this will be a commercial suit because it relates to export and import of goods. So if I could just, I'll save trouble, the time of this honorable court. I'll serve a notice on the plaintiff again. Lordship keeps it after 2 weeks. We'll also ascertain what has happened because for 10 years, I see 2 orders in 2013 and nothing has happened after that. Written statement is filed, no other steps have been taken, and this will probably be a commercial suit, so it will have to be transferred. But I'll put the plaintiff on notice again. He'll come back after.
None appears for the plaintiff. Although the learned counsel for the defendant is present. 6. 16 January. The learned counsel for the defendant shall send a copy of this order to the learned counsel for the plaintiff for intimation.
Great.
Item 3.
That I appear for the plaintiff in this matter, my lord. The suit was decreed, my lord. Ex parte, my lord. The defendants have not appeared, my lord. The decree was for eviction. Now, my lord, for mean profits, your lordship was pleased to appoint a special referee. Now, my lord, in that case, my lord, we will be needing some more time because, my lord, the dealing person of the plaintiff, my lord, he is an aged person who resides at Surat. So naturally, my lord, it's taking some time. My lord, I would
submission. The matter is adjourned to.
My lord, I'll be seeking for 2 months' time because so that I can come up with the entire thing being complete.
2nd April for submission of report by the special referee with liberty to mention.
Great. Deeply obliged.
Item number 4 and 5.
For corrections, what corrections?
I appear for the defendant number 1.
What corrections are to be made?
My lord,
23rd December.
Make a correction by pencil and hand it over. Hand it over. Next 6, it will be corrected.
Grateful.
Item number 6.
But here we see modification of a decree which was passed by this honorable court on an earlier.
Who is the other side?
My lord, there's no other side. May I indicate, my lord was pleased to pass this order on 26th November 2024, my lord, directing the registrar to file a report communicating this order to the defendants, my lord. The registrar has filed a report. Lordship was pleased to peruse that report on the next date when the matter was taken up, that is on 13th December 2024. And Lordship has recorded in the order dated 13th December 2024 that service has been effected. But since service was effected just a few days back, Lordship was pleased to adjourn the matter and keep it today. My lord was pass orders on. My lord, may kindly have a look at the order, my lord. Lordship was pleased to pass on 26th November. And this thereafter, my lord, on 13th December, Lordship has been pleased to pass this order, my lord. Order there.
13th December, it was adjourned.
Yes, my lord. My lord, it was adjourned, my lord, after Lordship has perused the report of the learned registrar.
That it was very recently served, so let there be some breathing time.
Thereafter, my lord, matter has come up today because Lordship has directed the matter to come up today. My lord, that breathing time has been given to the defendants.
Modification of the decree.
Yes.
Why the modification is necessary?
Modification is necessary.
Where is the application?
My lord, perused the application, my lord, was satisfied, my lord. And thereafter, Lordship was pleased to pass this order on 26 November 2024. And the parties are at consensus ad idem, my lord. The defendant numbers 1 to 9, my lord. They all envisage the desire to sell off their respective shares in the joint property, my lord, to the plaintiff, my lord. That is recorded in the Commissioner of Partition's report. Lordship was convinced by
Regard to sale of the property.
Yes,
What modification you are seeking for?
modification to the extent, my lord, let there be a direction upon the defendants to sell their share. My lord, since the defendants are not here, my lord, let an order be passed in terms of prayer B of my application.
Then why the direction or decree will be modified? You have to execute it.
My lord, because
Where is the decree?
the decree, Lordship, will find.
If the decree is for conveying the property, then you have to put it in execution.
This application, my lord, the commissioner's report on which the decree is based, my lord, final decree, but it records that all the defendants are willing to sell off their share in favor of the.
Now they are not doing that.
Yes, my lord. Now modification, my lord, because in spite of the fact, my lord, the defendants have envisaged the desire to sell their properties, the Commissioner of Partition records that it is conspicuously silent about that, my lord. we joined issues over here, my lord.
You
When
drop execution proceeding then for conveyance, for registering a conveyance.
this might be construed as an execution proceeding itself, my lord. Kindly have a
Why?
my lord, in as much as the fact that all desire to sell off their property, my lord,
Maybe they're not now. They are not doing.
that has been recorded, my lord.
Maybe they are not doing that.
Yes, my lord.
They
Now
are flouting the decree. Then
they-
you have to obviously drop
no, my lord.
execution
The
proceeding.
decree, my lord, there was no deduction for sale. Kindly have a look at the decree.
Then how this can be done?
My lord, that is where we join issue and say that the decree ought to be modified to that extent, my lord. Because
Then the judgment is to be. Decree cannot be modified in that matter.
kindly have a my lord, the judgment, my lord. We see
Where is the judgment?
page 82. Page 82, my lord.
Report of the learned partition commissioner shall be part of the decree.
Yes, sir. I have perused the report of the learned commissioner. Since there is no objection to the report of the learned commissioner of partition, the report prepared by him may be accepted. According to the report of the learned commissioner is
Where is the report of the commissioner? Where is the decree? Decree টা আছে এখানে?
commissioner's report starts at page 36, Lordship. Page 36, the commissioner's report starts. The relevant portion is from page 38 onwards. The commissioner report considers all, my lord. Meetings were held, my lord. Thereafter, valuation of the property was held. Properties, my lord, the all.
কমিশনারের রিপোর্টটা কোথায়? That will be part of the decree.
But my lord, the commissioner's report starts at page 36 of Lordship's brief. That is annexure F. Annexure F, Lordship. Page 36, my lord, the commissioner's report starts. The relevant portion is from page 38 onwards. Lordship has marked his excess earlier. I've taken Lordship through this report. Then place the report once more. Para 6 constitutes.
Parties are at addendum to sell the property. So this is part of the decree.
Yes.
So obviously the parties will have to sell it. If they are not willing to sell, then it is to be put in execution.
Therefore, my lord, prayer B, my lord. Let the registrar be directed.
Why the registrar will be directed?
As much as the fact that the commissioner report
Commissioner report is there.
takes.
Now you want to execute this registered deed of conveyance. If they are not willing, that is not mentioned. If they are not willing to do that, in spite of passing of the decree, the only way is to drop execution proceeding.
My lord,
This is not the proper way.
my lord, to the
No,
extent,
not
my lord,
modification.
as much as the fact, my lord,
The learned counsel for the plaintiff filed the instant application for modification of the final decree for partition. Full stop.
my lord, my guide hears me on this point, my lord. Why
Yes,
is
I've
it
heard you.
modification?
I've got your point.
Because, my lord, the decree, in spite of the fact, my lord, all the parties are willing to sell off their share.
They have
the
not done.
decree does not
They have not done.
Yes, my lord, the decree.
That's
does
why
not
execution is to be brought about.
My lord,
Execution proceeding is to
my lord, by this application, my lord, we want to modify the decree to the extent that the parties may be directed to sell, in as much as the fact that the parties were consensus item at the point of sale, my lord. That has
কি
been
বললাম?
recorded.
Full stop. It is contended that in the report of the partition commissioner, it is mentioned that parties were ad idem to sell the property.
The defendants in favor of the plaintiff, my lord. Defendant 129.
Valuation was also made.
My lord, may I come back on the text, my lord, bring judgments to the defendant, my lord, that this sort of modification can be done, my lord. Kindly grant me Well, at some time, well, I shall come back.
Need not be pending for long.
Well, kindly answer is 48(7) bring the judgments, Father. To the effect that this sort of a modification
কি
can.
বললাম?
Well, kindly transmit sometime.
Mm-hmm.
The report of the partition, it is mentioned that parties were at adjournment property. And also was also there.
It is also contended that there is no legal impediment in the event necessary direction is passed by this court to defend number 1 to 9 to effect sale of their respective shares. Full stop. The plaintiff seeks modification of the decree, seeking for a direction to the defend number 1 to 9 to sell their respective shares in the property for consideration as stated in the report. Heard Mr. Laha, the learned counsel, appearing for the plaintiff in part. Fixed 16 January for further hearing.
Can it be 18 instead of 16?
18?
Yes.
I will not come. She will come possibly. Will you come?
No, my lord, the code is 6, then we can come.
21st January. We have to drop execution proceeding.
But I shall bring the judgment.
All right,
When his
show me.
lordship is satisfied, one of them.
Item number 7.
My lord, this is my application.
Hmm.
However, my lord, I'm told, my lord, the copy has not been served upon my learned friend. Therefore, my lord,
Trademark or copyright matter?
no, it is a simpliciter, my lord, a suit which has been filed by my learned friend, terminating my tenancy, my lord.
Eviction suit.
Eviction suit.
So
They are
for
tak-
commercial purpose.
It was for commercial purpose. However, they had taken out an application under Chapter 13A of the original site rules, which has been dismissed. They filed an application for review. Review has been dismissed. We have taken out this application for seeking extension of time to file written statement. But it
No, should
appears
it go to commercial division?
But I'll indicate one thing. This
In
is
plain ta dekhiye ekটু.
only one thing, I should indicate whether it should go to the commercial division or not.
Hmm.
There's a section 106 notice. So, there's a conflict of judgments now, and it has been referred to a larger bench. Justice Shubhoshaji Bhattacharya's judgment that, Deepak Polymers, that
I know that.
in a 106 notice, commercial suit will not be there.
It
It's
is
not a
referred to
commercial-
larger bench.
Yes, because Justice Krishna Rao in a
Yes,
matter has deferred and has referred the matter before the larger bench, and it's pending before Justice Shen's division bench. Justice Shaw mentioned. So that is why, I otherwise would have wanted the matter to be transferred to the commercial division, but we should ideally await the
wait
outcome
for
of
the
that.
judgment.
Yes.
Yes.
But this has not been served. If they could serve
What is GA5?
GA5 is my application seeking extension of time to file written statement. Because their Chapter 13A was pending, my lord, we could not have filed the.
How long would you take?
My lord, I will take 10 days time to
I am
file the
opposing
written
this
statement.
application. But I am opposing this application. I like to use an affidavit.
On prayer of the learned counsel for the defendant, time is extended to file written statement
I'm opposing this. I'm opposing the application.
till 24th January.
No,
Although it is severely opposed to by Mr. Gupta.
kindly, it's a 7 years delay. But I'm opposing the.
Not 7 years delay. Their
I want to file
application
an opposition to the application. It's a 2018 suit.
there was COVID
They
in
have-
between. They had
they
taken
have
out
not
Chapter
filed the
13A
application for
in
7 years.
2019, which has been disposed of very recently.
This is the reason for not serving. Pendency of an interlocutory application is not a ground for not filing the written
Chapter
statement.
13A, when
But
it
I
is
shall- I
pending,
shall
one cannot
try and
use
satisfy
written
your lordship
statement.
on that. But I kindly permits us to use an affidavit, to this GA. And it has not been served. The GA has not been
All right.
served.
File you.
But G has not been served.
Wait,
Kindly
wait,
direct them to
let them
serve.
file, my lord, I'm not standing in the way, let them use it.
Mr. Gupta, learned counsel for the plaintiff submitted that copy of GA5 of 24 has not been served. 24 January. Copy of the application shall be served on or before the returnable date. Let the suit appear in the list on 24 January. You must come with a written
Yes,
statement
yes,
on that
I'll
date.
come.
But
I'll come. It's
only,
ready.
24 January, but any other day. And my lord, kindly permits us to use an affidavit.
I shall supply them copy by tomorrow, my lord. I'll give them copy,
তাহলে
let
লেখো,
them
copy
file.
of the application shall be served within 2 days.
I shall কালকের মধ্যে
Affidavit in opposition shall be filed within 1 week.
Ah.
Affidavit in reply
Well, it
within
has
1
been
week
served,
thereafter.
my lord, it has been served. Even if it is not, I'll serve again. আমি আবার
Let
দিয়ে
the
দেবো,
matter
কোনো
appear in the list on 29 January.
দিয়ে দেবো। My lord, there's another item number 14, my lord. But in this,
Another application
yes,
is the same suit.
same suit, my lord, I'm seeking 2
GA
weeks.
number
6.
5 of 24 and 6 of 24 shall appear on that date.
Well, I would like to file an affidavit, my lord. Lordship has granted me the time.
Exchange of affidavit shall be complete in respect of GA 6 of 24. On or before the returnable
No,
date.
it is a different point. কোনো অসুবিধা নেই। No, my lord, I'm seeking extension of time to use affidavit.
Exchange of affidavit to be complete. I
Different.
pass the order.
চলো, fees কম হয়ে যাবে কি?
Item number 8 and 9.
Lord, I appear.
6 weeks time, my lord, because my lord has directed me to file the additional written statement.
What is GA1 and GA3?
My lord, GA1 is their application for summary judgment. And in that, there are certain defendants. I appear for the defendant number 1. We had filed an application for leave to defend. That application was allowed. Thereafter, we were allowed to file a written statement. We have filed the written statement along with the counterclaim. If your lordship takes your lordship's order dated 25th November, everything is very succinctly recorded in that order. They were given time by your lordship to file the additional written statement to the defendant number 1's counterclaim.
Additional written statement by the plaintiff.
6 weeks time, my lord, because the director who is taking care of the
On prayer of the learned counsel for the plaintiff, time is extended by 6 weeks for filing additional written statement by the plaintiff. The suit will appear in the list on 3rd March.
Deeply. Lord, item 9 is also a connected GA application.
Dependent number 4. Dependent number 4 is not
So let the suit appear. None appears for defendant number 4.
Deeply.
Item number 10.
যে তাহলে উপরে লিখে দাও, none appears for the defendant number 4.
4. Deeply.
Item 10 and 11.
New Year will at first appearance.
Yes. This I have heard in part possibly.
Millard, this lordship was hearing me, Millard. Mr. Ghost has submitted, Millard. That Millard, there are Millard, 2 applications. First in board, Millard, is item number 10 is my application for 340. For section 340 of the Code of Criminal Procedure.
Yes.
For taking cognizance of the offense, Millard. The statement there, Millard, I just summarize whatever will admitted facts I say. Statement is that the person, Millard, who is the defendant, number 1.
I've just forgot it.
He says that he was not present, Millard, when his uncle has passed away, but he was present, document was there. This is the allegation there. So, Millard, it's a false statement or note, which is covered by 195, section 195 B2 of the Code of Criminal Procedure. Now, Millard, second application is my learned friend's application. Defendant, that
GA4.
GA4. It's for Millard 340 against the plaintiff, my client, who that is Millard. He said that he has filed a section 10 application before this honorable court. That was actually not filed. It was affirmed. It technically could not, so it's a false statement. Also affidavit on oath, also covered by the same section, section 195 B2. Now, Millard, I have filed the application. It is now on board. It's item number GA6. That's already on board. Now, Millard, so there's a
Where
third
is GA6?
2023. That's also been filed. Today, not there, Millard, it's filed. This third application, which is on board, it's my learned friend.
My
for
application
substitution
under
the heirs of a deceased defendant.
So how many applications?
there are
GA3,
Three, today,
3,
Milord,
4,
there
and
are
5.
3, 4, and 5. So
5 is
Milord,
not appearing today.
5 is appearing, Your Lordship. Item number 15.
that Milord,
Okay.
I just give the overview and I
Your
give
Lordship.
10, 11, and 15.
Yes,
now Milord, there's a substitution application of the deceased defendant number 3.
not exactly substitution. If
Three. Defendant number
it's,
1.
I am only seeking a leave under Order 22, Rule 4, Sub-Rule 4. Your Lordship remembers that suit Anindo Shaha, which Your Lordship extensively heard and passed a decree. There also the issue arose with regard to the leave of Order 22, Rule 4, Sub-Rule 4. So,
Milord,
same, the same nature
May
application.
not be because
I forgot that one.
Justice Krishna Rao has held, Milord, that substitution of the heirs of defendant number 1 is not permissible and that application has been dismissed. Today, Milord, in a circuitous way, Milord, whether Milord, they can take out this application because there is a finding to that effect.
Have you filed Leo?
I have
Filed,
filed.
Dev.
They have
I am
filed.
yet to file the reply. Your Lordship
Reply,
kindly gives me 2 days. We will affirm and
That's a
serve
different
it.
set.
That is in,
That is in
just a minute.
GA5.
GA5.
Yes, Your Lordship.
So far as 340 is
One by
concerned,
one, one by one. Affidavit in reply is sought to be filed in GA5 of extension of time is prayed for by Mr. Dotto for filing affidavit in reply in GA5 of 24. Full stop. Accommodation is allowed. The same shall be filed on or before the returnable date.
Your Lordship, one more thing and that I'm beseeching. Since GA3 and GA4 are 340 applications, and this, Your Lordship, is an application altogether of a different nature, Your Lordship, the hearing would be separate. So I am only beseeching Your Lordship that if any separate date is granted for the hearing.
only one thing. There is one problem. So far as substitution has been dismissed,
That
estate of Milord, the order has not been challenged. The estate of defendant number 1 was Milord is not represented that date, Milord. So, Milord,
So that I will hear on the next date while
that
hearing
has
this application.
just abated as a whole.
That will hear. So this will come first.
Yes. This Lordship can take up the 2 matters. now.
Any day, Your Lordship.
GA5 of 24 will appear in the list on 6th February. GA3 of 24 and 4 be affected. Fresh service of summons shall be made to the other defendants. Let the matter appear in the list on 24th February.
But all of them have come back saying addressee left. So I'll just make another attempt as per your lordships.
That up to you. What will you do?
No, lordship.
Whether substituted service or not.
Lordship.
Keep it in record.
Lordship,
Affidavit of service be kept in
Your
record.
Lordship, time for affidavit in opposition be extended for.
Time is extended for filing affidavit in opposition and affidavit of reply till the returnable date.
Item 13.
Article I appear for the plaintiff. Siddhartha is appearing for the defendant number 1.
Who is appearing for defendant number 1?
Siddhartha, the Mr. Zainab.
I'm appearing for the defendant number 1, Lordship.
You are for?
Plaintiff. I remind your Lordship of the facts of the case.
GA4 is pending.
Yes, madam. I shall not place, madam, your Lord. I shall not place. This is suit for partition. The property inherited by 3 brothers. 2 brothers have died. And I am, the plaintiff is wife or widow. But the defendant number 1 is contesting and other defendant is not contesting. After contested hearing, my lord, the preliminary degree has been passed. Partition commissioner appointed. And commissioner failed to amicable partition failed. Then my lord, valuation report, it was found that the property is not partition. Therefore, my lord, the valuation made, my lord, 49 lakhs and odd. In that situation, my lord, I filed an application for my lord to publish in the daily newspaper, fetching better value of the property, which will benefit.
Sale is agreed upon.
Sale is agreed upon.
How can you say this?
I tell you that. And thereafter, my learned friend, my lord, submitted before the earlier bench that this property cannot fetch more amount. That is why I made this application GA4. And thereafter, my client has got a purchaser of rupees 62 lakhs. And to that, my learned friend agreed that he will purchase instead of selling the property to the outsider, he will purchase. This is on record. And at this juncture, my lord, your lordship directed to start the defendant number 2 once again through the police station. And that was failed. In spite of service, they did not turn up.
That's a separate issue.
That is separate.
Have you filed that? Have you did that?
That was done. That was done by the learned register. That is.
Where is the report of the register?
Fact remains, my lord, my client is a widow and ailing. But she does not now want, my lord, paper publication and for bringing better price, my lord. My learned friend is agreed to, my client is agreed to sell the property at 62 lakhs, which my learned friend agreed, my lord.
No draft notice was submitted.
Because, my lord, I submitted on the last occasion, my lord, my client does not want, my lord, for better to issue public notification for fetching much more price, my lord. That is why I have submitted before the lordship on the last occasion. I do not want to place this section here 4. And prior to that, there is a report of the learned register that service has been effected. And my learned friend submitted before lordship that he is trying to contact over telephone to the defendant number 2, my lord, but that was failed. I want, my lord, the property should be, my share should be sold to the defendant number 2 as he agreed. Defendant number 1 as
Just a minute. Who are Rituparna Saha, Ritusri Datto and Rita Datto?
They are the, my lord, other. They are the widow of Dr. Dr. And they are others are the sons and daughters.
Now you want to sell the property to defendant number 1.
Yes. Because he has agreed that will your lordship.
What about defendant number 2, plaintiff number 2 and 3?
We are all of we.
Report of the learned register shows that learned register dated 30th September 2024 showed that Defendant number 2, 3, and 4 were not available, and possibly there were none at the residence, at their respective residences. It is also in the report that defendant number 2 to 4 are residing abroad currently. It will be useless, therefore, to make a publication. It is submitted by the learned counsel for the plaintiffs that defendant number 1 is willing to purchase the property at a rate of rupees 60 lakhs.
62 lakhs.
They have mentioned 60 lakhs.
That is the order.
Para 23.
And I have subsequently I brought out.
How can I pass that order on the basis of your submission when your pleading shows 60?
I'm showing you lordship, my lord, the order. Okay. Just
File a supplementary affidavit.
Your lordship kindly paid. Your lordship kindly produce, my lord, order number September 4, 2023. Page 2. Then it counsels for the defendant number 1 further submits that as per the report of the proposed valuer, if the present market value will come less than 62 lakhs, the defendant shall purchase the said property at the proposed sale price of rupees 62 lakhs. After
Learned counsel kotha kete din. It was noted in the order dated 4th September 2023 by the coordinate bench that a proposed purchaser offered price of rupees 62 lakhs. So defendant will not purchase it.
defendant number 1.
Defendant number 1. It was also noted that defendant number 1 is willing. Who is defendant number 1?
I am defendant number.
Are you ready and willing to purchase?
There is two problem in this. One is that he wants litigation cost of rupees 5 lakh rupees. Another thing is that 2, 3, and 4 and it's not appearing. Their shares, I think,
Should be deposited.
Deposited to the High Court original site.
Yes.
If that is to happen, I will be in a
Your
situation.
lordship has to decide, my lord, the
He was not-
litigation cost. And I leave it to your lordship, my lord.
It was also noted that defendant number 1 is willing
to purchase the property at a price of rupees 62 lakhs. Full stop. After hearing both the counsels, it is directed that the property may be sold at a price of rupees 62 lakhs by the plaintiffs to the defendant.
Only share of the defendant number. Plenty.
Full stop. Defendant shall retain the money value of his part of the share. In fact, when the property is sold to defendant number 1, that means plaintiff. But so far as the other defendants are concerned,
That my lord, to be deposited with the register.
who will purchase their shares? Who will convey their property, their share?
But whenever they will approach before the otherwise, my lord, the defendant.
Who will convey the property? Presently, the property is owned by all the defendants.
And I shall transfer my share in favor of the defendant number 1/3 of the undivided property.
Yes.
And 2/3 will remain with the possession will remain with the defendant number 1. So far, the remaining 1/3 is concerned. But whenever they will come, my lord, they will.
Therefore, the plaintiff, it is directed that the plaintiff are at liberty to convey their shares to the defendant number 1. 62 lakh is the value of total property. So your share will bring
1/3.
One
One
third.
third. But it will come to my lord, I tell you, lordship.
20 lakhs 66,660.
If it has to pay me, my lord, this amount, along with the, my lord, 2/3 of the, my lord, the
Stamp duty.
I have paid, my lord, that.
33,000.
Who will bear the cost of stamp duty? You. Defendant number 1.
33,333.
And also, your lordship,
After hearing both the parties.
lordship, one thing.
The valuation, next para, the valuation of the property stands at 62 lakhs. Full stop. The plaintiff shall transfer their respective share to the defendant number 1 as agreed upon. On the basis of valuation of the property. The consideration money shall be proportionate to the respective share of the plaintiff of the total valuation. Now, so far as this part is concerned, defendant number 3, 4, and 5, they have no right in this money.
No, man. So far,
because their right is not jeopardized.
No, their right is not their right retained with the High Court's, my lord. Whenever they will come, my lord,
They can transfer. But this money, since plaintiff is transferring his share, they are not entitled to the money. Plaintiff is transferring plaintiff's share.
1/3.
1/3. So how the defendants can be entitled to the money?
This money is, when the defendant will come,
Their money.
their money. That
So the rest of the portion is not transferred as yet.
Yes. He will be in possession of the 2/3 property.
So far it is made clear that the respective shares of the defendant number 2, 3, and 5 remained with them. 2, 3, and 4 remained with them. Conveyance charges shall be paid by the defendant number 1. Litigation charges you are claiming 5 lakh.
4 lakhs, what I have claimed. You
Would you pay something?
No. I have also defended the suit for more than 7
Pay
years.
10,000.
And I have been dragged before the Lordship's Court by Lord since 19.
A litigation cost of 10,000 shall be paid by the defendant number 1 to the defendant number to the plaintiffs. 10,000 is good enough.
And your Lordship kindly consider since
He is bearing the conveyance cost.
all right, what he is enjoying.
And the value, what if it's 62 lakh, value is 20 lakhs or something.
20 lakhs 66,000.
Whatever that means, 21 lakhs. So considerable money is to be invested for that.
That is there.
Then GA 4 of 22 stands disposed of accordingly.
And your Lordship kindly fix any time limit for
Fix
within 2 months or that or 1 month, my lord.
4th April for further order.
Lordship, one thing I want to clear it out. The rest portion of the share, do I have to deposit that in the original?
No, they are not entitled to any money because their shares are remained intact. Defendant number 2, 3, and 4 are not transferring their shares.
But Lordship, suppose I'm right now taking this property, but I'm in a situation right now is that I cannot sell that, I cannot remodel that, whatever they think I cannot.
In that case, we have to come again before this court. For
Then I will
direction.
be the petitioner and I will file the suit.
Yes. Not suit. This is a partition suit. Parties can be interposed at any time. Yes.
Item 16.
Protection, my lord, I am submitting one thing. My lord, your Lordship kindly clarify that the stamp duty to be paid on the basis of this valuation. Otherwise, my lord,
Why should I make clear? This is the consideration money is to be paid.
Well, because at present, my lord is aware that there is a separate valuation made by the collector when the deed are placed.
Come, if you face the problem, then you will make an application.
I'm submitting this on only when it will help my.
If the consideration money is 20 lakh, then that because you are afraid of something else. You are afraid of the valuation will be go according to the recorded value.
Recorded value.
No, that I cannot pass.
That will
Let if you pass, you come separately.
Item 16, my lord, I am for the plaintiff. My lord, in terms of my lord's previous order, the demerit application of the defendant GA7 is to be heard first. Pleadings are complete in respect of it. And my lord, my interim order is still today. My lord, so my lord, if they
What
move,
is demerit application?
my lord, GA number 7 and GA number 4. GA7 is the defendant's application. GA4 was filed earlier, my lord, by one party claiming to be a director of the defendant.
Copy of that application has been served.
That's
upon
also, I mean, that is nobody is also appearing for that. So, my lord, GA4 possibly can be disposed of because
No, my lord,
because
we need to know what is the application about. We are not aware because
the
no copy has
applicant
been
is not before your
served.
lordship.
My
The
lord,
applicant is not before your lordship. The
Lordship, I am
applicant
led
has
by
to,
Mr. K.T. Thakkar. He's there appearing virtually.
if Mr. Thakkar makes his submissions today, my lord, kindly grants me leave to give my response on the next day.
My lord, we are, my lord, trying to, my lord, get hold of the copy of GA4.
GA4, the applicant is not coming
know
before
as
your
on date
lordship.
what is the application about, against whom it has been directed. Nothing we are aware of. My lord, let us ascertain
None
GA4.
appears for the
applicant
in GA4 of 2020. Full stop. GA4 of 2020 is filed
My lord, may I get a copy of GA4? My lord, if I may request my learned friend
by
to hand
one
over a
Naveen
copy.
Chandra Ojha.
What did he look?
Full stop. The learned counsel for the
My lord, for the defendant, your lordship.
defendant submitted that copy of the application has not been served upon him. Let a copy of the application be served upon the served of all the parties if not served already.
Well, the applicant has to serve. Otherwise, I can to expedite the plaintiff can give because Naveen Ojha nobody is appearing for.
Yes, well, that is what man I am seeking.
Direction is given to serve. The party who has filed the application is supposed to file.
Yes.
If the party is not appearing and not serving a copy, the application will be thrown away.
No, my lord, only one thing, my lord, may I request your lordship for one thing? My lord, if my learned friend is
If you
having
are
a
so
copy,
eager,
if
if it is not served,
if I can get a copy from my learned friend, he is willing to give.
that's up to you.
Yes, that is
And my lord,
all.
the interim order, my lord, is still today. My lord, kindly extend.
Interim order is extended till the returnable date. Let the matter appear in the list on 25th February.
Grateful.
Grateful, my lord. Only one thing, my lord. If I may request my learned friend to give a copy of that.
Well,
GA4
that will be, yes, that of course. That
deeply
will
obliged, your lord. Deeply obliged.
Yes, sir.
Item 17.
May it please the Lordship. That today I shall conclude. One clarification I have not made very clearly. We have relied on three grounds for establishment of a right to use the compound for delivery of cars from the showroom. Those three grounds are all independent of each other. The right which accrues by reason of long user, that right accrues irrespective of whether that right is necessary for the enjoyment of tenancy. To cite a judgment to that effect, a landlord has impliedly granted a right which may not be necessary for enjoyment of tenancy. Tenancy is not relevant there. Second ground we have taken.
You can say it's a kind of accessory license.
It is then given right given by the landlord by the long user of 50 years. Normally have 20 years or more. Second ground we have taken that is necessary for enjoyment of tenancy. Because tenancy cannot be enjoyed for the purpose of running the showroom and delivery of cars unless we have access to the rear gate, etc. That is matter of evidence. And we have analyzed the evidence and we include our note to show that this showroom from the inception of tenancy had no facility or possible facility for delivering the car or bringing the car from the front side. Front side is abutting on Fiscal Street, Mirza Ghalib Street. And that is, as a showroom should be, front side is covered by three glass windows, which are from ground to ceiling. Therefore, it cannot be approached. But third gap, third pillar of third way of we call it, that has got a ceiling, a glass ceiling, but not up to the ground floor. That is, that level is there. The gate is 4 feet, and we have evidence is there. Is a 4 feet wide. 4 feet wide. 4 feet, 4 feet some inches about wide, through which the customers and ourselves can enter on foot to the showroom and exit from the showroom. But car cannot pass. The ways or the doors at the rear is a gap of 11 feet to 12 feet each. Three of them we have closed when we wanted to air condition, but left one. That is the only way, 12 feet wide, through which we can take in a new car and deliver the new car to the customer who drives it away. This is not second right. This is the second. Third right, we have said this is a question of, is it statutory tenancy? Tenancy still survives, even if contractual tenancy is terminated, or statutory tenancy survives and remains subsisting until decree is obtained for eviction. Therefore, statutory tenancy, I am still a tenant. And tenancy, as defined at the West Bengal Premises Tenancy Act, defined the tenant, both 1956 Act and 1997 Act. Both definitions are same. Tenanted premises means all right adjunct thereto, appertainant thereto. Appertainment, as my lord explained, I am grateful to your lordship for saying, is mean incidental to the tenancy. Therefore, this right of bringing in cars and delivery of the cars from the showroom by using the passage for a temporary period, this is a 30 minutes to 45 minutes, as you have said. Car, it is not, we are not parking the car really on the passage. We are pausing the car for a short while, because at that time a sort of funfair is made or incidental accessories are fitted, etc. The mechanism or function of the car, how to operate, He's a switch for this, that switch for that. He explained to the customer. Car is paused on the passage adjunct to my rear gate, showroom's rear side, for short while, 30-45 minutes, then the car goes out. Drive, and then the customer drives up the car to the compound and they access the main road. The two main roads, Park Street and other road, mainly now Park Street. And this is the right, also independent right. So many times all three grounds are independent of each other and additional to each other. If one ground doesn't appear acceptable to court, other grounds is not necessarily defeated. All three grounds are separate existence. This is my submission and clarification I should have made. Now, my lord, this is a case where my landlord wants to deny a right which I have been admittedly, I say admittedly, exercising for more than 50 years with their knowledge, without any objection, without any interruption. Now, landlord decided to file a suit, not for eviction, but for preventing me from using this back exit for delivery of cars and bringing cars in. Delivery of cars, parking, they think it is parking, pausing the car on the passage for 30-45 minutes for temporary period. They think it is parking, and that is their case. But Lord, you have seen the definition of parking. A car being left in a particular place for a particular purpose and particular period. When we park our car, let us say in front of the High Court, and we come back after for definite time, and we come back thereafter for specific purpose. Here, my lord, the car which is 45 years, I'm leaving at that question whether this pausing of the car really amount to the parking of the car, then my lord decide. Dictionary meaning of parking lot to see we have seen. Now, the landlord, after allowing this right to use the common the passage, the common compound or courtyard as they call it, which is adjunct to my showroom. Why there are 4 gates, 12 feet wide, on the back side of the showroom, which straight away leads to the passage. I mean common compound. Straight away. Why the landlord given me a showroom with four doors openings leading to the compound or courtyard as they call it? Unless they accepted that would have a right to use that compound for ingress and egress. And why is 12 feet wide openings? 12 feet wide, that openings are not required. The 12 feet wide openings in the back, 12 feet wide openings are not required for human being passing. This showroom was being used as a showroom by India Automobiles before we were inducted as a tenant, and they were also using a showroom, and same way. So it is clear from the conduct of the tenancy and the four wide admitted position left, through which any vehicle can pass from the showroom into the compound. It is necessary that such wide openings are necessary. They can afford away necessary. Only if it is intended that the vehicles which were displayed in the showroom will come out of it and will go in and come through those openings and meet the compound. So this right was there for the purpose was given. But not after expiry of 50 years, admittedly, after long use of 50 years, landlord thought of filing the suit but denying his right. Now, when they filed the suit, decide to file the suit, they must have been legally advised that this long user of 54 years will stand in the way. So what they did, just on the eve of filing of a suit was filed in September 2000, 4th September 2009. And on the 1st September in the evening, some iron pillars were placed in the backyard. Photograph was taken by my landlord, a managing director of the company, the private company really, with his own camera. And it was his own only, his evidence that I have taken the photographs. And then these iron pillars were removed. Admittedly, from paragraph 8 of the plain law to find, when the suit was filed, these iron pillars were not in existence. There is no obstruction. There is the question that this removal was done by the defendants before filing suit. But when they were placed, in the plain there is no amendment. When those iron pillars were placed, paragraph 8 of the plain, oh my lord, no amendment. Then comes the question of evidence, oral evidence of the managing director PW1. He is unable to say when it was placed. He says the evidence is there. I don't know, we cannot give this date. Then after constitutional examination, he says, when giving evidence, it was 10 years before, when he was giving evidence in 2017. 17. Evidence is if we calculate back calculation of 10 years from a date of deposition, when it's giving evidence in this court, it comes to the 2017, they placed the iron pillars. 10 years were taken in 1956. So let us take their case. Up to 2017, admittedly, it is 50 years have passed. 51 years have passed. When they first tried to create an evidence of disruption of the long user, and that evidence was not there when suit was filed. Question was raised, to find that it was not at all there. Because if iron pillars were there in the back side of the showroom, then no car could be delivered. And we have evidence of independent witness, namely who came and purchased of the car. Challans, documents are all exhibited. They took away the car, delivered the car in 2008. Sorry, I made a mistake, not 2008. If you make the back calculation from the date you are giving deposition.
19, 20, 20, give deposition. 2019 and 2020 your deposition.
It was done in some date in a year, not you give the year only, can give the date, 2010 or something. No, before it will be 2007. He was giving evidence 2017. He was giving evidence, and if you give 10 years back, it comes to 2007. That is oral evidence. But we have got direct evidence of independent witness that in 2008, a delivery of the Hyundai car was taken through the back door, to the using a compound. But next question, that is the only question, fact really, which are in dispute in this suit. When they were placed, iron pillars were placed. It is in evidence, this gentleman PW1 admitted. Paragraph 8 of the plain, my lord, can you see? No date is given when it was placed. Then when in evidence he gave it was placed, then naturally, my lord, paragraph 8 of the plain, defendant and the agents have on 2nd September 2009, wrongfully illegally caused the removal of iron pillars and iron bars which are standing on the compound.
Which paragraph you are referring to?
Paragraph 8 of the plate. Can you see paragraph 7 also? The case is defendant do not and cannot have any right in respect of the aforementioned compound inside Karnani mansion or any portion which is adjunct to the back portion of showroom. If I don't have right, then why do you have 4 openings, 12 feet wide each, on the back side of my showroom? You see, number 3, paragraph 8 now. Dependents and or their agents and servants have on 2nd September 2009, paragraph 8. As on 2nd September 2009, what he did not. Suit was filed on 4th September 2009. 4th September. So plaint was kept ready undoubtedly. It's not that suit was ready. Plaint was kept ready undoubtedly. And wrongfully and illegally caused removal of iron pillars and bars which was standing on the compound. Since when? Not mentioned. Not mentioned. After removing such iron pillars and bars, dependent and their servants have
cemented
the area where the iron pillars stood and have now started parking several showroom cars at the back side of the district. Now, Milord, the witness was under cross-examination. Question 145. I'm reading out, Lordship, don't have to take out. Reading out 145. When were these iron pillars, which were illegally cut by the defendant, according to you, as you have deposed, were installed? It was done long before, many years ago. Full stop. Next question. Can you indicate the approximate time? It was more than 10 years. Is giving evidence on 24th July 2017. So it was done, let us say, in 2010. 2007, 10 years, 2007. And we have got the evidence of 2 customers with the documented of sale who took delivery of the cars from this showroom on the back side in 2008, up to 2008.
So your point is, since 2007, these iron pillars were constructed, or iron pillars were put into there.
Yes.
Tenancy is from 1951 or something
56.
like that. 56. So there is no mention, no evidence that since then there was iron pillars.
Yes.
So that's why you are.
That I'm placing. And this hinting at is done into iron pillars there, placed in 2007, is untrue because cars were actually given delivery to the back side in 2008 also. But then comes the question, my lord. Apart from the oral evidence of placed the car in 2007, was there any documentary evidence? I asked the witness, if you place the iron pillar, cost is said to be 1 lakh in the Plaint, you must have in the books of account record it. Entry should be there. Well, yes, entry should be there. But if we haven't disclosed that, why don't you disclose it? No. So, my lord, it is, if the books of account were disclosed, that will indicate the expenses. But that is not so relevant. Expenses, what is more relevant is a date. Is a date when those expenses are incurred for iron pillars. The books of account will mention the date on which iron pillar expenses were incurred. That was why it was not produced. The temporary etc. done on the 2nd September. Our case is, it was done on 1st September, plaintiff had removed. But plaintiff case is that no, defendant removed. Very well. Assuming defendant had removed. If the iron pillars, according to oral evidence, was placed in 2007, that was illegally placed. Because from 1956 up to 2007, more than 50 years had elapsed, and my right, arising crystallized by long user, had crystallized and had become indefeasible after expiry of 20 years from 1956. So if the landlord illegally wrongfully try to obstruct a right or disrupt a right which have already enjoyed for 50 years, then he has the right to undo it. I'm not going to that question at all. I'm saying he done it rightly.
Your point is putting up iron pillars doesn't make anything for you.
Never. It was not there. My witness said so. I didn't. They placed it, took photographs himself, and next it was then it was removed. It was not. It's a iron pillars, and similar. There could have been. It's important. Could have been documentary evidence of date when they're installed, if they're actually installed, and the cost expenses. That would be in the books of account. He admitted, yes, there have been books of account, limited company, but did not produce. This is not an adverse inference on 102nd 14 Evidence Act E clearly arise. And therefore, my humble submission would be, your lordship will consider this case of installation of a iron pillar in 2007 or even thereafter. Well, it cannot be relied upon by court. Suit is being filed on 4th September 2004.
2009.
Sorry, 4th September 2009. And in the plaint is averment that on 2nd September 2009, my clients had removed it. And the plaintiff made ready overnight and filed. That they were planning to file a suit for denying his right. Must have been advised by lawyers that it is difficult because long user. So they created a story of placing of iron pillars without stating in the plaint that it was placed or it was there when the tenancy was granted. Or that it was placed, let us say, in the 1958, 2 years after tenancy. Or it was done within 20 years up to 1956. That a case which is not made out in the pleading, and very important part of the pleading. Removal is something different because they are not in existence who was filed. But this right we are enjoying uninterruptedly without objection since 1956 tenancy. And that's why we are utilizing the 4 openings in the back. And this right, even if sought to interrupt in 2007, would be illegal disruption, illegal interference. Because we are cited the judgment to your lordship, that a right after 20 has become indefeasible. A right granted by the landlord, maybe a very generous landlord, without necessity, he is granting a right to the tenant. Then this right cannot be what they call, there can be derogation from the grant. A grant is implied, there can be derogation from the grant. When the grant has become absolute and crystallized into
Inevitable.
grant of a crystallized right, dev right. So after judgments have cited for 30 years right of way, enough. 20 years right of way. In fact, lordship knows under 20 years it become law of prescription, become enough. And the admitted even according to the own case, in 2007, it was sought to be disrupted. It was sought to be. Right has already been exercised long user of more than 50 years. 50 years, 51 years.
The first point is it is annexed to the possession or rights. Second alternative point is it is acquired by prescription.
Yes.
And third point?
Third point is not, it is appertaining to,
yes,
incident of tenancy. This is necessary for enjoyment of a tenancy. Because if the back entrance is blocked, then I cannot bring in cars in my showroom for display, and I cannot deliver the cars to my customers because the front side is blocked.
Yes, I understand.
Showroom.
Have you filed the notes of argument?
Yes, well, was ready. Filing it to Demila. There are the judgments you have signed. Now, my second problem as a lawyer is what argument they would make, I would not know. But it is my duty to deal with some of the defense which maybe they have hinted at. Not I shall just briefly tell you, Lordship, what arguments I could they've orally made, sorry, not evidence they've made. For the first time, they say that is Exhibit A, their standard agreement, is an agreement of tenancy. We have dealt with this point in note also, Lanyard may hear it, that this is a case that the agreement of tenancy was there, dated, a document which dated 1956, is not a case made out in the pleadings. Therefore, under Supreme Court judgment, reference 2018 Supreme Court, the fact case which is not made out in the pleadings, court has no jurisdiction to entertain such plea. This is first answer. Second answer to that point is that you say this is the Exhibit A is the agreement of tenancy. We say we cannot raise that point. Exhibit A, the document, is not referred to in the plaint, not even referred to in the documents relied upon in the plaint. So that document cannot support this. Suppose that agreement of tenancy, yes, it agreement tenancy contained in that Exhibit A. Then question arises, does the agreement or contract contain all the terms of tenancy? Does it contain all the terms? We've listed 17 essential terms which are not mentioned. I've given the list. The plaintiff himself has given evidence, oral evidence, plaintiff, regarding the area of the tenancy. But the tenancy agreement does not mention even what is the area of the tenanted premises, covered floor area or what to be. That is given in violation of Section 2091 and 92. Or he himself given evidence, it was 4,400 square feet area. Then he has given evidence on the terms of tenancy also. Terms of tenancy also. We have given the tenancy agreements. These are the essential terms which are not mentioned. May I mention some of them only? Some of them we can mention. Area of the showroom is not mentioned in that Exhibit A. That location and description of showroom. Why is that located? Which floor not mentioned? That witness has said, his witness said, on the ground floor. See. And which floor is not mentioned? It is a three-story building. It may be third floor thing or not. This is essential terms I'm mentioning. Who will pay the municipal taxes? That is not mentioned in the tenancy agreement. Exhibit A. This totally silent regarding ingress and egress to and from the tenanted showroom and into the adjunct compound. Now coming to third point, I'm giving a list of so many, not similar time, I up to I. Just give your showroom at N, A to N. We're giving that the term tenancy. But then I'm coming to third point on this. But admittedly, the Exhibit A does not prohibit, does not contain any provision of prohibiting use of the compound which is adjunct to the showroom. So if it does not, if the agreement of tenancy would have been used to them, if the agreement of tenancy provided the tenant shall not use the compound which is adjunct to the showroom by parking the car or otherwise. It does not do so. I have cited judgment to show if the so-called agreement tenancy does not contain the prohibition, then it doesn't matter. Then court can see, court will decide, yes, you have been allowed your conduct of the parties. See the conduct of the parties of the tenancy agreement. They have allowed for 51 years to use this compound and allowing egress and ingress to and from the back door on foot and also by vehicles. So that is that judgment we have given. I shall give a list of a judgment to my learned friend so that he'll be knowing what judgment I will be giving. And as my lord desired, we prepare a list of the judgments in a separate spiral binding with an index indicating the keywords for what proposition they are being cited. করেনি করেনি রেডি করেছো when Virat he has prepared the keywords is not completed. I'll give it the next day. Give it next day. Give it to the next day. But not I can inform the learned friend. I'll this is the I'm giving to him so that he knows what judgment we line. I can place the judgments. I'm willing to. I brought all the judgments here. This is spiral binding. 12 judgments we're relying upon.
I will go through it, sir.
That we not our 3 judgments have cited our proposition that Section 91, 92 Evidence Act has no application if the agreement, alleged agreement, do not contain all the terms, including Supreme Court judgment and 2 other judgments. So section, they cannot argue that you cannot give evidence regarding use of the compound because this exhibit A.
Evidence can be given of usage.
It is. And but this case is not made out in the plaint. There's the agreement of tenancy, exhibit A, that document is not even referred to in the plaint. Is not even mentioned in the list of documents relied upon. Such is sprang as a surprise and they make out this case. So Section 91, 92 Evidence Act do not apply. Plaintiff himself has mentioned other terms of the tenancy, oral evidence, namely area, namely municipal tax, etc., all these things. It was given. We need not object. Lastly, my lord, can you consider when you are reading evidence regarding user of the compound in the backward, no objection was raised. That is, evidence is not admissible. Under Section 91 or 92, whatever case, no objection was raised. Now, my lord, in course, argument is that sought to be raised, I shall vehemently object. Cannot be raised. And that is not the fact either. A tenancy agreement with standard agreement doesn't stand in the way. Firstly, my lord, that this exhibit A cannot be considered to be agreement of tenancy because that is not the case made out in the plaint or even in the annexes. Secondly, I have said that this agreement tenancy clearly on the face of it, expressly, do not contain all the essential terms of tenancy. Namely, area and other, I've listed them. Same, A to 9 listed the items. And thirdly, we say that these exhibitations which is supposed to be agreement tenancy do not prohibit, do not contain any provision for prohibiting the tenant from using the adjunct compound, which is accessible through the 4 wide openings by the landlord. Yes, you know, had that it may raise the intention of tenancy agreement that we shall not use the compound for parking the car or any other purposes, then that will mention in the agreement. On this point, you have referred to evidence that all tenants, all other tenants of all tenants, Kannani mentioned, a huge number of tenants, they have been freely parking the car on the compound overnight. This is admitted by plaintiff number 1. All tenants are allowed to park their car on this compound overnight. And I'm not parking the car overnight. I'm just passing through this. Last thing that we have said that this user of the compound by me for the purpose of delivery of car has not caused any discomfort or inconvenience to any tenant or even to a landlord. In 1960, when we were washing the cars on this compound, lot have seen that. Then we stopped that. Yes.
So next step, you will file the compilation of judgments.
Ready, and the keywords.
Giving keywords.
Yeah. Notes ready, like deliver the notes today. And
do it next day.
Next day. Very
next
good.
with compilation of judgments and the notes of argument.
Judgment I can give in and keywords.
When will you be able to come next day?
Whatever they need it will.
Hard in part. Today is
8.
8.
কবে এই
ডায়েরিটা দাও না।
বলবেন কি আপনার শেষ না না অজয়কে দিয়ে দিই। অজয় অসুবিধা হবে। ও তাহলে একে এমনি কিলোমিটার দাম 12টা কেস আপনার গভর্নমেন্ট আপনাদের 5টা পড়ে
জোর করে আছে।
এগুলো পড়িনি পড়তে চাই যদি পড়তে দেয়
21st January.
25 January. And when handing over list of judgment to a land dispensary so that he can 21st 25th বললেন তো
21st.
বল তুমি বলো
আচ্ছা একটু দেখে নাও, দেখি ডায়েরিটা দাও। হ্যাঁ না না ওনার অসুবিধা আছে।
He is now in key position because he is to provide the keywords to the judge.
Yes. Seventeenth is okay.
Yes, my lord. 17th. 17th, Lord.
I'm the only person free on any day.
Who am I? Excepting on 17th.
No, because my all both of them.
24th January.
24th January.
24th January.
Oh, bless.
যে শোনো
List of judgment will not hand it over to your land friend and next day.
রেকর্ডটা ফেরত পাঠালাম না আজকে চেম্বারে, ওটাকে আরেকবার দিও।
আমার বিল আমার বিল ও এইগুলো এইটা
Item 18
just kindly leave me, Lord.
Item number 18 and 19.
Your Lordship, on the last occasion, Mr. Suman Datto had relied on 2 judgments. There are few other judgments that Mr. Datto needs to further place before Your Lordship. Your Lordship, we are seeking a very small accommodation, an adjournment for not less than, if Your Lordship may not keep it this week, at any time the next week, Your Lordship. And we will also file our written notes of arguments along with all the judgments, Your Lordship, that we intend to rely upon. Anytime next week, Your Lordship.
Twenty-four is okay.
Your Lordship, my senior is not here, not in town from 22nd or 23rd, Your Lordship. I'm not very clear. But if Your Lordship may please keep it anytime next.
27, 29. একটা কাজ করো, এটা আগে করে নাও।
Johannes. No, not Johannes. Johannes.
17 January.
17 January, Your Lordship. Much obliged. Thank you, Your Lordship.
Hello, after they give their note, I'll give a reply.
On prayer of the learned counsel for the defendant. Defendant, further argument is adjourned to 17 January.
Your Lordship, 17 January, you'll be keeping it the second half?
Yes. Obvious. Any problem?
No. And then 16th is not available, Your Lordship. 16th is not available.
So many matters are there.
72. We have not invited.
All right, 16.
Much obliged, Your Lordship. My apologies, Your Lordship.
Any special event?
Unless we are.
Your Lordship is also. Your Lordship is also.
17 is a special event.
Many thanks, Your Lordship.
Then I can adjourn
My
for some more days.
No. 16th is good.
Their note because again I'll take another 2 weeks to come back.
16th is fine, Your Lordship.
Pending for a long time, my client also.
28th.
No. Your Lordship. 16th is fine, Your Lordship. Perfectly fine. Many apologies. Thank you, Your Lordship.
Item number 20.
The evidence has been completed. Your Lordship, today is fixed for arguments.
Who is the other side?
I
Lordship,
appeal for the
let me check these things first.
Lordship.
I reserved one matter for judgment, one TS for judgment. Now I start looking into the documents. I found a very surprising thing. No issues are framed.
In this matter, issues have been framed. Here,
I am not sure of. Unless I see, I am not sure of. Hopefully, will is exhibited.
yes, that I have done.
Death certificate is exhibited.
Lordship. Certificate.
There is no cause of action unless there is a death certificate.
That has to be. Death certificate is part of the annexure A to the application, but death certificate is not exhibited. Not exhibited. No. Death certificate is not. Check করে আসবো। But it's nobody's case that he has not expired. I appear for the petition.
Court will not be satisfied unless death certificate is exhibited. There is no case.
Death certificate is part of the filed. Death certificate is filed here.
Copy is there. দেখো এখানে হয়েছে কিনা উইলটা এখানে এক্সিবিটেড হয়েছে
Page the probate application is page
it
11.
is exhibit A. Original will is exhibited.
Original will is exhibited.
WS টা দাও তো where is the death certificate?
Page 11, page A, annexure A.
That is a copy. That is not marked.
No, this is a photocopy of the.
Yes, that is not marked.
But generally, when you file a probate application, we file the original will.
Where is that?
Original will is there.
That is there. Where is the death certificate?
Certificate original death certificate original is not. Department don't ask for it. We file it by the.
It is to be filed there.
We file the photocopy of the death certificate, but the original will is fine.
But so many witnesses are there. Why didn't you produce the original?
Generally, when that's not an issue.
আমাকে ওয়াকালতনামা দিচ্ছ কেন WS চাইলাম এফিডেভিটটা দাও ক্যাভিয়েটটা দিয়ে আমি কি করব
If the death is not an issue before the court,
this is to be exhibited.
I'm carrying the original, but
Do one thing.
none of the
File an application. On admission, I will mark it.
No problem.
I will mark it on admission. You need not call any witness since admitted document. Nothing is to be proved.
Only for the purpose of marking. Only for the purpose.
Only for the
I'll
purpose
give
of
my
marking.
consent, you know. Only for the purpose. We will. No, the death. Check. I was reading, but I didn't find the death certificate mark.
No, it is not marked.
No, death certificate is not marked. The will is marked.
Will is marked. That's okay.
Marked, the execution, all the signatures, everything is marked. But the will,
Death certificate is the genesis of probate proceeding.
That's the cause of action.
Yes.
Because otherwise, how can a probate proceeding is maintainable? It's a gentleman.
One counsel came before me, examined the witness and said it's okay, it's over. He did not produce any will. Will is annexed, but that should be identified. She was an attesting witness.
Yeah.
No death certificate is there. I said I am dismissing it here and now.
Here and now.
Then I found it has already been dismissed, not restored.
Okay, can't die twice.
No, suit was dismissed for default.
Default. The issue টা আছে একবার দেখে নিলে না
Issue is there.
Issue is there.
But I have to
Here.
check. Yes.
In this matter.
Yes. Issue is there. But let me see. আরে WS টা দাও না
Heading থাকবে
Affidavit in support of caveat লেখা আছে দেখুন নেই
caveat এর সঙ্গেই হবে
নেই তো ওকালতনামা caveat এর ফর্মটা আছে আর কিছু নেই
27 February 2018.
পারমিতা মুখার্জি
Yes.
because issues are framed on the basis of this affidavit, which is to be treated as WS.
That's the main issues: forged, fabricated, testamentary capacity.
If it is a case of forgery and fabrication, then issue should be there.
But those are there in the.
Then that issue should be here. That issue is not here.
Mark Mellard is in
In paragraph, they have made out a case. In paragraph 14 of the.
So I have to recast the issues. Because you know, so far as forgery, fabrication, all these things are concerned, this onus lies on the defendant.
Paragraph 14 of the caveat.
Oh yes, I have heard it. I have seen this.
No, Lordship had heard the when the witness action was going on.
Yes.
The last occasion, the lady was in the box. Argument we are supposed to commence. Paragraph 14 is the forged, fabricated, manufactured. Paragraph 15 is testamentary capacity. Testamentary capacity.
Forged, fabricated.
Yes. Forged and fabricated. There the defense taken.
Today is fixed for argument.
Given free consent. Yes.
Issues were framed as early as on 16 December. Issues were framed on 16 December 2022. Full stop. Issues are to be recast. Full stop. The following issues, the recast issues. Now, the issues are reframed as follows. First, whether the instant will is the last will and testament of the testator or testatrix. Testatrix. Whether next, whether the testatrix had testamentary capacity at the time of execution of the last will. Next, whether the will was executed out of free will and in a sound state of disposing of mind. ওইটা কেটে দিন কারণ এই ক্যাপাসিটির মধ্যে ওটা এসে যাবে whether 3 নম্বর লিখুন whether the will was executed by the testatrix out of her free will next whether there is any suspicious circumstance surrounding the execution of the will and the plaintiff is able to repel or repel the doubts. Next, whether the will is a forged and fabricated one. Forged, fabricated, and manufactured one. Next, whether the instant will was the last will and testament executed by the testatrix or not.
To the execution.
Whether the petitioner oblique executor is entitled to probate, grant of probate as prayed for. Full stop. Hard argument in part.
In the entire matter, Lordship, there is only one issue. Will executed in Modhamgram at 10:30.
Oh, প্রথমে দিন whether the court, this court has jurisdiction to entertain the suit.
will executed in Modhumgram at
Who will
10:30.
argue first, you or Mr. Mitro?
I can start, your
I
lordship.
can start. What can I do?
Who
I'm the
adduced evidence? Defendant evidence, adduced evidence. Who is the defendant?
I'm the defendant.
So you will start evidence.
I'll start.
Argument.
10:30, Modhumgram will has been executed. ARA Kolkata, that's the evidence. 11 o'clock they have reached.
So what is your argument?
Half an hour from Modhumgram till Governor House.
Okay.
That is sufficient.
Any argument?
So I'll make my arguments.
Argument over.
That's the whole. That's the most important thing. A person, a lady, your lordship, of age about 70 years, she executed the will in Modhumgram at 10:30. That's the attesting witness evidence. And your lordship, another person came and adduced the evidence who accompany her from Modhumgram, and he has said that he has reached RA Kolkata at 11 o'clock in half an hour, whether it is possible or not. At any stretch of imagination.
First thing. That is your first point of argument.
It is my first. The second thing is, your lordship, that particular lady had no testamentary capacity at all. Under your lordship, the
What evidence is
at the
there?
house, your lordship, I'll show all the evidences, your lordship, everything I'll show.
Today not this much.
No, lordship. Today, your lordship, first application has to be filed, your lordship, and death certificate has to be, your lordship, annexed, and then I'll start my arguments. But the thing is, shocking part is this, your lordship, whether thereafter, your lordship, whether will can be
Keeping it
treated as a
further,
suspicious will or not.
Definitely.
hard in part,
Definitely.
adjourn to
Put the application. Put that.
let me start someday. 27th?
27?
27 হবে? 27 January.
সোমবার হচ্ছে
Because I have so many interlocutory matters pending piled up.
27th of January.
No. Argument. Sorry. Not 27th. 28 January.
28 January. I'm great.
Company matters.
Company matter, item number 21, Indodeep General Finance and Investment Company.
Madam, for the official liquidator last occasion, your lordship was pleased to grant me leave to file the supplementary affidavit disclosing therewith some orders of this honorable court. Madam, may I file this supplementary affidavit along with the status report? Madam, my application, that is CA number 20, seeking, my lord, direction from your lordships for appointment of the valuer in respect of a particular property of the company in liquidation, my lord, for the purpose of, my lord, the sale. So this is the initial. If your lordships kindly see the summons for directions, prayer A, leave kindly be granted to the official liquidator to appointment valuer in respect of, there are 2 flats mentioned, out of which 1 flat P6-13.
Status report along with supplementary affidavit is filed by the learned official liquidator.
Yes.
What is the new report?
My lord, your lordships kindly see the report says, my lord, the details of the, my lord, kindly see the last line, if I may, last paragraph, and the, Lord, that is in the report itself, status report. Lord, if your lordships kindly see paragraph, page 6, paragraph 12. Page 6, paragraph 12. I have stated that an application being CA number 20 of 23 filed by the official liquidator High Court Calcutta for appointment of valuer to evaluate.
So valuer is to be appointed.
Valuer is to be appointed. Now, my lord, there are 3 flats which were taken possession by.
Valuer be appointed first.
My lord, prayer A, my lord, of the prayer A, my lord, summons for directions, my lord.
Summons টা কোথায়?
Prayer A, leave be kindly granted to the official liquidator to appoint valuer to evaluate the, my lord, flat. There are two flats mentioned herein, but one flat is.
Prayer A,
No, my lord, so prayer A in respect of the flat number P-1/3, because the second flat has already been disclaimed. That was the order passed by the Honorable Court. That is the reason, my lord, I have filed the
the
supplementary.
learned official liquidator is given liberty to appoint a valuer from the panel of this court to evaluate the flat number P-1/3
Indodeep Housing Complex.
Indradeep Housing Complex -1. Damdam is 74, Kolkata.
Yes, my lord, 74.
Damdam, where is it in Damdam?
My lord, after the Damdam is
In which part? 74?
North Calcutta, my lord.
No, not Damdam or South Damdam.
No, it is Damdam, my lord. It is written Damdam.
Damdam Road, Kolkata 74.
Damdam Road, yes, Kolkata 74.
That is connecting BT Road and Damdam
Yes,
Station.
yes.
The valuation report shall be submitted on this court on or before the returnable date.
And my lord, the prayer B also required, my lord, because I have to pay the my lord, amount to the valuation valuer.
Full stop. The matter will appear in the list on 24th February. Full stop. The learned official liquidator shall incur expenditure in terms of prayer B of the summons for direction.
And my lord, the C also required because the my lord, kindly see, I have seeking leave, my lord, to grant me leave to concern BLR LRO Barakpur to
Let the valuation be done first.
No, valuer will go. So my lord, that BLRO and the police Nagarbajar police station to cooperate the render
For
all
the purpose of valuation, concern BL and LRO, namely Barakpur-2, and officer inspector in charge of Nagarbajar police station shall provide necessary assistance and cooperation to the official liquidator. Accordingly, prayer C is also allowed.
I'm deeply.
22.
This is my application.
I'm for the
Item number
official.
22.
For official liquidator, my lord. In this matter,
Because your application, who are you?
I am the intending purchaser, my lord. Purchaser of the, my lord, development to be made by the company in question, my lord. The company was the developer, my lord. I have paid the entire money, my lord, along with the GST. And now, my lord, the IRP appointed by the NCLT, my lord, he will supposed to, my lord, execute the agreement for sale and, my lord, for registration of the deed, my lord. Similar order has been passed by this coordinate bench of this court, my lord. If your lords can have a look to the order, my lord, passed by my lord Justice Rohit Krishna Kapoor, my lord. So kindly have a look to this order, my lord.
This application is for prayer.
Prayer, my lord, for
Are rakho na ota.
kindly take some, my lord, judges, my lord.
Applicant submit an order be passed directing the respondents to execute deed of conveyance
My lord.
in your favor,
My lord.
conferring absolute right, title, interest, so and so. Now, how have you got your right? Is there any previous order?
No, there is no order, my lord. But what happened here, my lord? They have, my lord, symbolically given us the position. While physical position has not been given. I have paid up the entire amount, my lord. That has been admitted by the, my lord, IRP, also, my lord, the company in question, my lord. Now, my lord, similar occasion.
Yes, what do you have to say? Just a minute.
My lord, the official liquidator has nothing to do in respect of the matter, but the facts of the case is that Avoni Projects and Infrastructure Limited, they were the promoter, developer. They have developed several buildings.
Your view and your comments on this one.
My lord, we have already submitted a status report before this honorable court. My lord, that was in
status report. Have you submitted in this matter?
In this matter, my lord, I have yes. CP1 of 2016. My lord, it is dated 2nd February 2022.
কি বললাম ডিক্টেশন দিয়েছি the instant application is filed on behalf of who is Kavita Kumar? Who is Kavita Kumar?
Kavita Kumar.
My lord, Mithilesh Kumar and Kavita Kumar, husband and wife, my lord. Mithilesh Kumar, the petitioner number 1, and my lord, wife is Kavita Kumar.
On behalf of Kavita Kumar,
My lord, both are the applicants, well, Mithilesh Kumar,
as well as Kavita Kumar,
my lord.
seeking for a direction to the respondents. Who is the respondent?
Well, IRP respondent number 2. Ajay Kumar Agarwal, my lord.
Respondent number 2 means Ajay Kumar Agwal.
Ajay Kumar Agarwal.
Resolution professional.
My lord.
Respondents to execute necessary deed of conveyance in favor of the applicants, conferring absolute right, title, and interest of the property being flat number 1J on the first floor in block 3, having a covered area of 1314 square feet, together with one covered car parking space of the proposed new building named as Avani Estates, situated at 58 Gourango Soroni, Kolkata 70. That is also Dum 2. 78.
I don't think, no. It was not Kolkata. Down the Malay, it was, my lord.
Full stop.
Gorfa.
Well, it is
Just
Gorfa.
Gorfa. South Calcutta.
How have you got your right?
My lord, I have paid, I am the intending party, agreement was entered into between me with the my lord, company. Company was the developer, my lord.
Company means?
Company Adani, Avani Projects, my lord.
Avani Griho Nirman.
Avani Projects and Infrastructure Limited. Now it has been merged with the my lord Avani Projects and Infrastructure Limited. Yeah, initially it was there, my lord, Avani Projects Private Limited. Subsequently merged, my lord, and then known as my lord, Avani Projects and Infrastructure Limited.
This is in liquidation.
This is in liquidation. It has not been went on liquidation. Only advertisement has been made. And in the meantime, my lord, one creditor my lord, made an application under Section 7 of the Insolvency Act before the NCLT. NCLT, my lord, now my lord, appointed RP. My lord. Now resolution professional, my lord, has to execute the deed in my favor. The order passed by the coordinate bench, kindly have a look to the order dated 6 December 2023, my lord. Kindly, my
So
lord.
who is the now officially owner of the property? If it is liquidation official, liquidator is the owner.
No.
My lord, the RP has been appointed by the NCLT.
Oh. So you submit a status
Yes,
report.
RP is now representing the company in liquidation.
A status report is accordingly invited from the learned official liquidator. The same 4 weeks, the same shall be submitted on or before the returnable date. The matter will appear in the list on 4 weeks means
February, my lord.
18 February.
18. I'm deep.
It's at 2 p.m., my lord. 18
2 p.m. Not 2 p.m. exactly. After argument is over, after this witness action in the second half, I will take up company matters. Follow the list.
Item number 24. 23.
Are you in 24?
No, may I take back the order, my lord? Single bench order, my lord. May I take all this? Right. Single bench order I have given my lord, coordinate bench. Let it be my lord, with the record, my lord. Let it be with.
Keep it with you. When necessary, I will take it back. Who is there? None appears. Adjourn to 12th March.
SR Greenhouse.
Lordship, the application has been covered up at my instance. It's an application for dissolution. I'm for the official liquidator, Your Lordship. My Lord, there was a direction upon the official liquidator to submit the auditor's report, Your Lordship. The direction was passed on 14th June 2023. Lordship, accordingly, we have prepared the auditor's report, Your Lordship, but this has to be supported by an affidavit. So accordingly, Your Lordship, I'm just praying for 3 weeks' time or 2 weeks' time, Your Lordship, to place the auditor's report by
As
your.
prayed for, time is extended till returnable date to file the report by the learned official liquidator.
Auditor's report.
Auditor's report by the learned official liquidator. Let the matter appear in the list on 3rd March. Let it be filed first.
Get an email.